The Senate Appropriations Committee will please come to order. Clerk, please take the roll.
Senator Turner, Senator Lewis, Senator DeWitt, Senator Rose, Senator Villanueva, Senator Ventura, Senator Morrison, Senator Joyce, Senator Johnson, Senator Hastings, Senator Aquino, Senator Murphy, Chair Sims.
Present. A quorum is present. We have a request by Paul Elders from Blue Room Stream to video stream today's proceedings. Members, we will begin our work this morning with Senate Bill 4077, the Illinois Supreme Court, presented by Chief Justice P. Scott DeVille. Clerk, please add Senator Joyce to the roll. Your Honor, please join us at the testimony table. The floor is yours. Your Honor, if you'd like to introduce your team, we'd appreciate it.
Mr. Chairman, may I proceed?
You may.
Good morning, Mr. Chairman, and the members of the Senate Appropriations Committee. My name is P. Scott Neville, Jr., and I was recently elected by my colleagues on the court to serve as the 123rd Chief Justice of the Illinois Supreme Court. Today, I am joined by Marcia Meese, the Director of the Administrative Office of the Illinois Courts. She sits to my right. Cara McCaffrey, the AOIC Chief of Finance and Operations. She sits to my left. And Daniel Hunt, the Director of AOIC Probation Services Division. We are also joined today by the Honorable Robert Villa, Chief Circuit Judge of the 16th Judicial Circuit located in Kane County, and he's going to provide a local perspective on the importance of adequate state court funding. He sits to my far right. Mr. Chairman, to meet the evolving needs and increased demands placed upon the Illinois courts, full funding is critical to sustain our constitutional and statutory obligations. The judicial branch's fiscal year 2027 general revenue funding request of just over $573.8 million includes statutorily mandated funding that totals over $436 million. Put another way, over 75% of our funding request is statutorily mandated. This includes salaries for 990 judges, probation and probation officers' salary reimbursements, circuit clerk stipends, public defender funding, and support for other core statutory functions such as data collection. As Chief Justice, one of my responsibilities is to establish the strategic direction of the judicial branch for the next 3 years. This leadership role guides the vision and priorities that will shape the courts and their services throughout the state, including oversight of a variety of court programs and initiatives designed to serve all court users across Illinois' 25 judicial circuits of circuit courts, 5 appellate court districts, and the Supreme Court, ensuring that your constituents in every region are supported by our state justice system. The rule of law is a foundational principle established by both the U.S. and Illinois constitutions, stipulating that all individuals, institutions, and entities are equally subject to and accountable under the law. It ensures that laws are applied fairly, consistently, and transparently, thereby safeguarding individual rights. This is vital for upholding justice, protecting freedoms, and fostering trust in our legal system. As Chief Justice, I will continue the Supreme Court's commitment to improving public trust in the courts by ensuring justice that is accessible, simplifying procedures, and offering support services that meet litigants' needs. We strive to make the Illinois courts a national model, safeguarding the constitutional promise of equal justice without regard to who a person is, where they live, or what resources they have, so that all litigants are seen and heard. Our goals are grounded in the Illinois Judicial Branch's strategic agenda mission statement: to serve the people of Illinois and safeguard the rule of law by delivering justice that is fair, impartial, and accessible to all, upholding the state and federal constitutions, and earning public trust by treating every person with dignity and respect. The court has implemented several measures to streamline judicial processes and enhance efficiency for court users. In 2017, the Supreme Court launched statewide mandatory electronic filing, otherwise known as e-filing, for the Supreme Court, appellate court, and trial courts. E-filing now encompasses civil cases, criminal cases, and, most recently, quasi-criminal cases, enabling electronic submission of major and minor traffic offenses, ordinance violations, and conservation and civil matters. In 2025, the Illinois State Police and circuit courts began to develop bulk e-filing procedures for electronic traffic citations. ISP will be able to submit electronic citations to clerks, thereby eliminating paper processing. Our courts continue to prioritize equal access to courts for all individuals. Several programs, including the Foreign Language Interpreter Program and the Illinois Court Help Program that commenced in 2021, are essential resources for individuals navigating the Illinois court system. Illinois Court Help provides free, step-by-step assistance through phone, text, and email, assisting court users all across the 102 counties by providing clear, accessible information in both English and Spanish. In 2025, Illinois Court Help assisted nearly 30,000 individuals with inquiries regarding the court system. The ongoing technology modernization initiative within the courts, initially launched in response to the pandemic, has been essential for access to justice by enabling remote proceedings. Remote court hearings enable individuals to participate without taking off a day of work, incurring parking expenses, or paying for childcare. Our courts tackle challenges faced by vulnerable members of our population, including individuals with disabilities, at-risk youth, those dealing with substance abuse, and individuals with serious mental illnesses. These issues are present across our court system, including civil, probate, domestic relations, guardianship, juvenile, and child welfare cases. Many years ago, Illinois introduced drug courts to better address crime linked to substance use disorders using a problem solving as opposed to a punishment approach. The success of this approach has expanded to other models such as veteran court and mental health court. These problem-solving courts lower repeat offenses, reduce incarceration rates, and associated costs, saving money and encouraging defendants to give back to their communities. Illinois is a national leader with 122 certified problem-solving courts. Your local jurisdiction has at least one drug court, veterans court, DUI court, or mental health court. Problem-solving courts are just one small piece of the Supreme Court's broader responsibility for probation in Illinois, which is assigned by Illinois statute. Probation is a cost-effective, community-based alternative to incarceration that promotes lasting positive change as individuals rejoin society as productive members. While probation officers are initially locally funded, the Supreme Court is mandated to reimburse 100% of approved salaries across all 102 counties under the Probation and Probation Officers Act. The significance of ensuring probation funding has grown as a result of recent criminal judicial reforms. With Illinois' prison population declining, there is a corresponding increase in felony probation numbers. This shift highlights the crucial need for continued support and full funding for probation. At the end of fiscal year 2023, the Public Defender Fund was enacted and directed the Supreme Court to distribute funding to counties for public defenders and public defender services. This funding to counties across Illinois has been transformative for historically underserved local offices. Continued allocations are essential for the local jurisdictions to comply with the Sixth Amendment and provide effective assistance of counsel to those in need. In response to the recent mandates of the Funded Advocacy and Independent Representation Act, also known as the FAIR Act, the Supreme Court has continued to work with the executive and legislative branches to bring about the successful implementation of the Act and its goal of ensuring that indigent defendants receive quality representation throughout our state's 102 counties. The FAIR Act creates the State Public Defender Commission with an effective date of July 1st, 2026, along with the creation of the Office of State Public Defender as an independent state agency within the judicial branch with the implementation date of January 1st, 2027. To meet these statutory deadlines, a multi-branch, multidisciplinary transition team has been tapped to develop recommendations for strategic implementation of the FAIR Act. The remainder of our fiscal year 2027 request addresses essential operational needs for the state courts and other expenses to support the Supreme Court's constitutional responsibilities as an equal branch of government. I thank each of you for the opportunity to discuss the judicial branch's funding needs. I appreciate your commitment to ensuring the Supreme Court can meet our constitutional obligations as the third branch of government. I will now turn the mic over to Chief Judge Robert Villa, whose remarks will provide a court perspective on the judicial branch's funding needs. We will be happy to address any questions related to our funding requests that you may have. Chief Judge Villa.
Before we do that, clerk, please add Senators Turner, Lewis, Ventura, Rose, and Morrison to the roll. You're welcome. Your Honor, floor is yours.
Thank you. Good morning, everyone. My name is Robert Villa. I'm the Chief Judge out of the 16th Judicial Circuit in Kane County. This is my first time in the Capitol since I was about 8 years old, so I'm happy to be here. Thank you all for giving me an opportunity to provide to you what I hope is a bit of a fresh perspective on why funding is necessary for our trial courts. I won't bore you with all the things that go on in the 16th Circuit, but there are two main areas that I'd like to discuss with you, and one of them, which has become a constant concern for us, is funding for interpreters. Currently, in Kane County, our line item budget for interpreters has increased by about $200,000 a year for the last 3 years. That is a line item that our county board does not really understand and doesn't accept. And I'll say what I think is the quiet part out loud. I don't think all the members of the county board want us to have so many interpreters. They seem opposed to the notion that our court system should be catering to people who have language access needs. We currently have 20 different languages in Kane County that we service with interpreters. Spanish is the predominant one, but we serve Quechua defendants, Polish, Russian, Serbian, you name it, we have it. It's an increasing need, and what we find is that without the ability to fund that, we find ourselves in a position where we can't provide services to people who are involuntarily in front of us. One of the concepts that I have, and I hope that all of you understand, is we are certainly co-equal branches of government, but the difference between us is we receive everything. We don't do anything. We don't create task forces. We don't arrest people. We don't create filings. They come to us. And so it's our obligation, statutorily, constitutionally, to provide those services to anyone that comes in front of us. If our state's attorney accuses someone of a crime, we can't have them go to trial, even on a traffic ticket, without the ability to represent themselves and provide some type of defense, or at least understand what they're facing. So to the extent that there is ever a need from the court, and this is not just germane to Kane County, this is throughout the entire state of Illinois. I want to make sure that I'm giving you Kane's perspective, but every month the Conference of Chief Judges meets in person, and all 25 of us chief judges that represent all 102 counties discuss these issues. And this is predominantly a large one. AOIC has provided one method, and that is remote interpreters. And while that serves a good purpose for status calls and sort of rudimentary things of that nature, the one thing about our system that I try to remind people is that we are a human system. That's what we are. Imagine if you're in a foreign jurisdiction and you face something, whether it's a traffic ticket or a criminal case or whatever it is. You can't understand anything in the courtroom, but you're about to be accountable for whatever that you're accused of. And the person that you're talking to is in your earpiece or is on a TV. It removes that sort of support that an in-person interpreter provides for you. It removes that sort of comfort that there is another human being right there helping you get through what you're doing. So to the extent there's any request for the court on that side, I can tell you it is increasingly necessary as part of our human system and the accountability that we demand of ourselves as far as the service that we provide, that interpreters be supported. The other area, and the Chief Justice mentioned this, that there are more people on probation now, which is a good thing if you look at the statistics. But the other area where there are more people involved is mental health related opportunities. Chief Justice mentioned Kane County is proud to have 4 problem-solving courts: Veterans Court, a new DUI court, a drug court, and it's a treatment court for people with mental illness. The success rate is very, very high. We have failures from time to time. It's a human system. Sometimes people relapse. But for the most part, it's a way to improve the lives of people who have been before us and otherwise would have been incarcerated for 4 years. Instead, they do 2 years really difficult personal accountability time, and they come out the other end with a renewed relationship with their child and with a job, and having paid into our system for the privilege of participating in specialty courts, which makes them also accountable. But on the mental health side, which is separate from our courts, if you know historically that we used to have a centralized mental health way of dealing with things. In Elgin, for example, in Elgin, Illinois, we had the Elgin Mental Health Center, which I think historically housed maybe 3,000 people. At one point in time, it was an entire campus. It had a maternity ward. It had like 118 acres of land. And now all it's used for is cases where people are unfit to stand trial, and they're sent there for fitness evaluations and maybe to be restored to fitness. And for people who are deemed guilty, for lack of a better phrase, I know there's a better legal phrase, but not guilty by reason of insanity. We have decentralized our mental health, and so people don't have access to that if they lose their insurance, if they're homeless, if they're just 25 to 30 years old and they're no longer with their parents anymore, and they're not on their parents' insurance, and they work at an hourly job that doesn't provide that kind of insurance. So we see them. And the single most important thing that needs to be done is evaluations. On the more scarier side of things, I guess, sex offender evaluations, people who abuse children evaluations, but not just that. There are evaluations done in divorce cases to see who's fit to be parents. There are evaluations done of children who are in the subject of divorce cases where a GAL says we might need to evaluate this child to see whether or not they can actually go with this parent. So to the extent that AOIC has been very generous in providing those types of fundings, I would encourage you to continue to fund both interpreters and the mental health side. One of them provides a service to people who are, unfortunately in front of us to be accountable for whatever they're accused of. But also on the mental health side, we can't provide services to the community if we don't properly evaluate, properly monitor, and properly sentence people who suffer from mental health illnesses. And the only way to do that is to fund our ability to have those kinds of evaluations. Thank you very much.
Thank you. Thank you, Your Honor. Before we move the questions, Chief Justice, the clerk, please ask Senator Villanueva to the roll. Your Honor, any statements before we go to move the member questions?
No, other than to say that the court has a big need and to tell you that we're only 1% of the budget, and we'd ask you to consider our request for funding for 2027.
Thank you so much. Questions from members of the committee? Senator DeWitt.
Thank you, Mr. Chairman. Welcome, Chief Justice, Chief Villa. I have one quick question regarding mental health beds. In Kane County, which is a large portion of my district, years past, there's always been a real significant shortage with regards to the availability of mental health beds, I guess is the best way to describe them. It even got to the point several years ago when there was discussion about using what is now a DJJ facility, St. Charles Boys School, IYC, and actually mixing adult and minor populations just to try to alleviate the lack of mental health beds. That went by the wayside. And since then, IYC has become more of a vocational training center, which I was happy to support and help cut the ribbon when that transition was made. But is there still a significant shortage of availability with regards to mental health beds? I know part of the construction going on at the Elgin facility had something to do with increasing those beds. Does that problem still remain in the 16th?
It still remains, and for those in our area, there was an incident maybe 4 or 5 years ago at Delnor Community Hospital, which is now part of Northwestern, in Geneva, Illinois, where an individual at the jail created an incident for himself. He ate a piece of his flip-flop and choked on it and ended up at the hospital in the emergency room. While he was there, the deputy assigned to him failed in his duty at that moment, and he was disarmed by the defendant, who was not handcuffed to his bed. He eventually took a woman downstairs without detail, caused her great harm, locked in a room, and was fortunately that situation was resolved by a SWAT team. that hospital doesn't really want, as you can imagine, to take people with mental health issues from the jail or the court systems, and often does not anymore. It's always going to be a shortage. One of the things that we have in Kane County that is very unique is we have what's called the Kane County Diagnostic Center. It is one of the gems that we have in Kane County. It's headed by a very accomplished forensic clinician named Dr. Alexander Sang. There are 10 doctorate-level clinicians there, doctorate-level forensic psychologists there, who do all these evaluations for us, so that we can better understand if there is a need to have somebody go inpatient, we can find a place for them. While we're proud of that, and we're happy that AOIC helps us fund that, regionally it's been a resource for many different counties. The output that we try to make with the recommendations is stymied by the fact that there is no place we can really send a lot of people to. Right. And sending them home isn't always the right circumstance.
I appreciate that. Yeah, I think it remains an issue that I think deserves additional scrutiny, not only from a state funding standpoint, but one more burden on Kane County and their judicial system just isn't going to fix it. So I appreciate that background, and a little bit of time I have left here, that's something I will try to delve into and continue to put pressure on the governor and his staff and DJJ as well as DOC to try to find ways to help cure that problem. So appreciate the background, Judge.
Thank you.
Thank you. Chief Judge.
Thank you, Senator. Senator Ventura.
Thank you, Chairman, and good morning, Chief Justice. My question is on the problem-solving courts. So I think last year I asked the same question. What is the commitment of the courts to expand out more problem-solving courts throughout our state?
Dan, I'll ask you to expand on that, but we are constantly, we have a work group within our Justice and Mental Health Planning Committee that is constantly reviewing various jurisdictions, and we are growing the number of problem-solving courts and including recertifying the existing courts, but I will let Dan expand on that.
Thank you, Senator. This past year we added a number of courts. One was in Marshall, Putnam, and Stark County. We had another in Pike County and Monroe County. We're currently working with 3 courts, Clark County, Bond County, and Douglas County. In addition, we seek a number of state and federal grants to be able to expand, so not just start new courts, but courts that currently have a population and they want to be able to serve more within that particular court. So we currently have 3 federal grants that come to through the AOIC and the Supreme Court's budget to pass through to the local court. So it is something that, as Director Mee said, that we are proactive. We are engaging local courts, local judges, as far as helping expand what they're currently doing or into new communities.
Just to add on to what he said, those problem-solving courts solve problems that people have who have special needs, and they're just invaluable to our court operation. I've just been amazed at how the Veterans Court has helped people who have drug problems. They're just invaluable in our system.
Thank you, Senator Ventura. Senator Turner.
Thank you, Mr. Chairman. And it's quite fitting, Mr. Chief Justice, that we're in the old Supreme Court room. We're glad that you're here. Thank you so
I
much.
noted that. I feel like I'm at home.
Thank you all for being here today. I just had a couple of questions, and I don't know who wants to talk about it, about e-file. So I know e-file is in the Circuit Court, Appellate Court, and it's presently working in Supreme as well. Is that correct?
That's correct.
Okay. And the other thing is how, I think you might have, Director, it might be directed to you. I think you have a committee, perhaps, that's working on the whole, how e-file and the correspondence is working with DOC. Does that work well, the electronic correspondence with DOC?
Yes, we have an Illinois Judicial Conference task force that is specifically focused on improving, if you will, the communications and coordination with DOC. And that task force has produced some pretty significant recommendations on improving that process. So
That's great, and thank you for working with them. That's very helpful to know that is a continual conversation, how we can better that.
Yeah.
I think that was all.
it was really more the technology on the DOC end that needed to get.
You're right, and that's what I think that we've heard also. And thank you for, I'm a former probation officer back in my day, so I started that way. So thank you. AOIC did a great job of helping educate all the probation officers as well. So is there, since I heard one of you say that there was an increase in probationers, I believe, is there an increase in how many probation officers will be, new money toward them? Is that something that we will see?
Dan, do you want to speak to that?
There has not been an increase in probation officers. However, as sentencing reform has taken place, many of the lower risk or low end into the system has been diverted. Then those have been replaced by the individuals that had previously been sentenced to Department of Corrections. So largely across the state, we see an uptick in the felony cases that probation is working with. So our probation officers' caseloads across the state are relatively static, maybe up a little, but the complexity and the difficulty of those cases are up. So that's where the training and the efforts that go into having qualified, trained, and skilled probation officers is paramount as the cases and the individuals they work with become increasingly more difficult.
All right, thank you, and thank you all for your service.
Thank you, Senator Turner. Senator Rose?
Welcome. I've got a couple just general questions. What is the average length of time of disposition of a civil case and a criminal case?
Yeah, sure. I just looked at that data.
Well, whoever wants to answer.
They're different. Criminal cases are resolved sometimes much more quickly, usually more quickly than civil cases for several reasons. One of them is a defendant may make a speedy trial demand, in which a case gets resolved in 120 or 160 days, depending on when they make the demand. Criminal cases are less cumbersome as far as third-party information goes. So once police officers get most of the information, basically the prosecutor has most of the evidence ready to get cases moving. A large portion of criminal cases plead out, so they don't necessarily go to trial. On the civil side, it varies. If you're talking about small claims...
Yeah, let's just talk about small claims.
Sure. Small claims is a shorter window. Those cases are not multi-year. In Kane County, in particular, is where I can speak of. Those are not multi-year litigation cases. They don't take that kind of time. They are, by statute, a different type of case. Their packets that they submit they're not required to submit the rules of evidence or follow the rules of evidence so much. So they're able to submit submissions and evidence back and forth to each other and get their cases resolved either at trial or even if they go to mediation at a much quicker time frame, under a year usually for those cases. A medical malpractice case is much more difficult to set a timeline for because the third parties that weren't existent in a criminal case are truly existent in a medical malpractice case. Nothing about the court is going to inspire speed from a doctor to get to give us his time to resolve, the depositions that have to be taken, experts. Sometimes it takes 6 months to get medical records. I've issued threatening warnings of contempt of court of $1,000 a day, and they still ignored me just to get medical records from varying departments. So I think it varies. I can tell you from a Kane County perspective, we have busy court calls, but there are no backlogs in terms of our inability to provide what I think is timely justice in our criminal cases and in our civil cases. There are outlier cases always. There always are. There will be defendants who have fitness issues. And go ahead.
What about let's go back to small claims.
Sure.
And sometimes I think even as dumbed down as small claims is, I think we've sort of made it too hard for the average Joe or Jolene to access? I mean, most people just give up.
Well, I don't know, in Kane, if I could say that most people give up. I can tell you that there is a disadvantage in small claims, and it's as follows. If you're there on an $8,000 credit card bill, and I'm the lawyer for Citibank, I've done 1,000 of those cases in the last month and a half, and you just lost your job and are trying to figure out why I'm in trouble on something I didn't voluntarily do. I didn't voluntarily not pay my bill. We have cases where, for example, if you get into a car accident or if you have damage to some physical item, you can't get relief in the small claims court from damages until you pay the bill. You're not damaged by the estimate of the bill. You're damaged by the payment of the bill. So many people do give up when they realize, well, I have a $5,000 estimate for my vehicle, and you're telling me I'm suing somebody, I have a right to sue them, but I can't get relief until I pay the bill and then bring it in as a damage? And we say yes, and they give up in that circumstance too.
Senator, I think you might be concerned about something that concerns me. The court is well aware of all the people in small claims. We refer to them as self-represented litigants. We are trying to address that problem. That is, in particular, one of the things I'd like to work on during my 3-year term as chief. And what I'd like to do is to find pro bono representation for self-represented litigants. And I'm attempting to convince my colleagues on the court to incentivize pro bono work by giving lawyers CLE credit. You should know
That would be a great incentive.
right. We're aware that maybe 70% of all civil litigants are self-represented. So it is a concern.
I mean, I'll just tell you, I made a mistake of watching this terrible made-for-TV movie about the Hatfields and the McCoys, and they recreated a trial circa whatever time frame that was in Kentucky, and literally the traveling circuit judge shows up for the afternoon. It was over and done in 5 minutes, mainly because the pig had already been eaten that was accused of being stolen, right? And I just looked at it and I thought to myself, my goodness, how simple that was. And then I look at whatever courtroom in my district, and thank goodness I haven't practiced in a courtroom in 20 years, but I wouldn't want to go in a courtroom today. I don't know. I mean, the constituents I represent, and granted, I represent a rural area. My second question is one around what communications are you guys having with our 3 public law schools about admitting more in-state students who are going to go be prosecutors and public defenders in, downstate Illinois. And I'm a proud graduate of the University of Illinois College of Law, and I got enormously well-qualified kids from my district that have got, perfect GPAs and letters of recommendation from the presidents of their colleges that can't get into the U of I College of Law, and all they want to do is go back to Douglas County that you just mentioned, literally, and practice law. And oh, by the way, we're down to one. We got a prosecutor and an assistant and a public defender, and I think that's about of all the lawyers left in Douglas County. 20 minutes south of Champaign, you can't find but 3 lawyers for the whole county. So, we can have all these conversations about this and that and the other, but who's going to do with this?
Well, I'd like to report to you that the Supreme Court is very concerned about legal deserts. There, in fact, is a special task force addressing the problem in legal deserts. What you just suggested, that is, getting the local law schools to admit some of these students, that's something we are talking with the law schools about, and we're also trying to figure out ways to encourage graduates from law schools to go to areas where there's a big need. So it is a work in progress. We are mindful of the problem, and we're trying to address it.
Well, it's interesting you say that. I'd love to talk to you more about it offline, because I actually had a bill for several years that never made it to committee that would have required our schools, not just legal, but medical, that are in-state institutions ought to be admitting in-state residents who want to stay here, nursing, healthcare, medical, the whole legal, the whole 9 yards. And I'd love to talk to you about that offline. Let me ask you one other question following up on Senator DeWitt, because the other thing I hear all the time is the mental health issue that you raised in your remarks, and Senator DeWitt followed up on. What is it? So here's the question. You've got someone you want to receive services, and granted that and the more acute front end, they've just been arrested and they're suicidal, and this isn't a matter of just letting them cool off or sober up. It's a matter of they need actual institutionalized immediate treatment. And I think immediately of Crawford County, where we had someone who was suicidal and wasn't able to be held under the Safety Act because the crime they were accused of didn't allow them to be held. And so they walked out the door of the courthouse and tried to kill themselves across the street by burning a house down on top of them. I'm sorry, a machine shed down on top of them. Luckily for them, halfway through the building burning down, they decided they didn't want to die that day, so they simply opened the door and walked outside the burning building. Unluckily for the guy who's building it was it burned down. We also had to send the fire department out, which obviously caused cost to the taxpayers, not to mention safety for the firefighters and EMS staff who were on site. What does it take for us to finally get to the point where we can get people mental health treatment when they need it?
That's $1 million question, and it's it's a circuitous. On the mental health side, they are slow to. There's no beds, so the fitness evaluations can't take place, and they don't go back to the court system. You can say more from your.
Do we know what the timelines are? I mean, if you order.
Well, before we get to what I might order, your acute situation circumstance is outside the court system,
right?
And it's law enforcement, and even in our jurisdiction where we have very large communities that do have significant resources, they're very short on officers who are properly trained in crisis intervention and have developed relationships with maybe hospitals or providers. Elgin and several others have it because they're larger, but the smaller communities don't have it as well. I can't imagine more rural counties would have the money or the capacity to train and have officers who can do that. So if somebody is arrested in a circumstance like that, under the Safety Act, their first appearance court would be something that they would have to come to within 24 hours. If that information is brought to us at that time, the court can make a determination of whether or not to put somebody in. There's several different statutes, I won't bore you with them, but they allow the judge at that time, at first appearance court, to order an evaluation, have somebody committed for up to 72 hours. Those things are available. The Conference of Chief Judges has just circulated a brand new order from Maureen Ward Curry, judge out of Cook County, who put that together for us, to assist judges on the bench who might not even know that they have this remedy, especially at first appearance court. So for me, to triage that acute issue, once it gets to the court for first appearance court, they can do it there. But your circumstance that you gave us the example is the one that really the judiciary is out of, and that is when we have a non-detainable offense.
Yeah, that's and I don't think this was ever the intent of the Safety Act, but in this case, the guy's own public defender was begging the court to hold him or her. I'll be honest, I don't know if it was a man or a woman.
Yeah. We're also training on the sequential intercept model. If you're familiar
but
with that.
what is the wait time just to get a bed from any court? Weeks, months?
It varies.
It could be 2 days to 2 weeks.
2 days to 2 weeks, okay. And do we have any idea how many beds that would need to get to immediate?
No, and I'll tell you why. Because the nature of this particular occurrence is really cyclical. Not even cyclical. That suggests a repeatable cycle. I mean, it's so varied that sometimes we have a large number of needs, and some months we have low number of needs. We have a juvenile detention center that sometimes has 14 people in it and sometimes has 50 people in it. And I raised the issue of the juvenile detention center because you would be saddened to know the number of people in there who are receiving mental health treatment as juveniles because they have to, and that's the reason why they're in that facility. So it varies based on time and circumstance. I wish I could give you a better answer, but I think it's something that would have to be studied and an answer given on a region by region, county by county basis.
Thanks. I'd love to help
I'd
participate
like
in
to
that
say
study.
that undiagnosed mental illness is one of the major problems in our society, and it has been estimated that maybe as many as 25% of all the people in the Cook County Jail have a mental health problem.
Thank you, Senator Rose. Senator Morrison?
Thank you, and I'm grateful for all of you being here. This is a quick question. It concerns, my analysis shows a stipend increase for the circuit court clerks. And I wonder if someone can speak to that. I do understand that the contention is that there are a lot of additional responsibilities since their last stipend at $6,500. But does your budget then pick up the balance? Are you picking up the extra $30,000 roughly? Can you speak to that for me?
So this is a result of conversations that were started last year. The circuit clerks, as you indicated, have not had a stipend increase since 1999. And so through conversations with the Clerk Association leadership, they were seeking an increase to $35,000. And we said, well, that's fine. We're not certainly going to oppose that, but we need to know what you're seeking because that we would have to make the appropriate adjustment within our budget. And so when we were putting together the budget for fiscal year 2027, we ascertained and confirmed that the Clerks Association would seek legislation increasing the stipend from $6,500 to $35,000, and that we would, for our part, that we would seek additional funding in our budget. I'm not sure where where the clerk legislation sits at this moment. I don't know, Kara, if you want to comment on that. The last we heard that they're thinking of going about it a different way.
But to follow up, isn't the stipend doesn't that currently come out of a county budget?
No, we pay.
You already
We
pay.
pay $6,500. Yes.
Okay. So I've seen legislation in the last 3 years, talked to a lot of different county officials who have come in with the same plea. I think this sets us up, if we do this for the circuit court clerks, I think this sets us up for every other county official who maybe is not in your budget, but that is also going to come in and say, we are also doing more work. We are also doing different things. I'm just kind of putting that out there as seems like there is a fairness issue. I think all of the county officials could all say they are doing more with less.
I'm sure that's true.
Thank you.
Thank you, Senator Morrison. Senator Rose for a follow-up.
Sort of on the same song, second verse of Senator Morrison's comment there is a jury pay issue and, finding jurors to actually show up and do the job. And who pays the juries right now? The county funds, or does that come out of your budget?
Counties.
Okay. And is it set statewide?
Yes.
Yeah.
Daily rate?
Yeah.
Are you asking if it's the same?
Yeah, could you pull that microphone?
Yeah, I'm asking, is
we can't hear.
the jury pay issue set statewide? Or is that set by county?
No, that's county.
So each county has the authority to pay jurors differently. I don't know if that's, okay, whatever.
Isn't that correct?
I didn't think so. I thought it was just statewide.
Yeah, I think it is a statewide.
Oh, okay.
Yeah, I think
Sorry.
you guys said it. It ends up becoming an unfunded mandate to the counties. There was a movement somewhere along the lines to increase the jury pay issue.
Yeah, I recall that.
And I heard this from a lot of my county board chairs who are really concerned that they don't have the funds to pay it. Where's that stand?
Where does what stand?
The order to increase the jury pay issues. We'll take this offline. If you just follow up, I'd appreciate it.
Yeah, why don't we get follow-up on those issues? Okay. Senator Murphy?
Thank you, Mr. Chairman. And Justice Neville, thank you for being here with your staff, Your Honor. I wanted to drill down a little on some of the analysis in our reporting on your budget. And first, you're requesting a head count increase in the juvenile detention centers. Can you elaborate on that for me and why you're budgeting for juvenile detention centers? And that's not under the juvenile budget.
Sure. I think it's a two-part answer. Is the first I'll say is that the head count is not to the Supreme Court. Those are local employees of the chief judge, and then the statute in the Probation Officers Act requires us to reimburse their salaries. And so it's not a FTE increase to the Supreme Court's budget. It would be an FTE increase at the local level. And that was for the detention centers. Since those are under the authority of the chief judge, then the AOIC has standards in that for juvenile detention centers. So that's the reason we speak to it. And the Probation Officers Act includes detention in the definition of a probation officer, so that's the reason we reimburse those positions.
So the intent is in probation, because we only have 220 kids in custody right now.
There are 220 youth in custody in Department of Juvenile Justice. There are many more in the 14 local county detention centers. So this is specifically for that only. And so then the Illinois Department of Juvenile Justice that has the state facilities has roughly the 200 or 220 youth.
Okay. Then to move on to the cost of living adjustments that you're requesting, $16 million for cost of living. Can someone elaborate a little on that?
Yes. Yes, Senator, that was projected prior to the publishment by the Department Bureau of Labor's. We calculated at 5% for the 1,718 employees, 990 judicial employees, and that is published at 3.2%.
Okay, I'm going to ask you, because my next question is what your total head count is.
Yes, our total head count right now is 1714, and we've requested an increase of 4 to 1718.
And so you're budgeting for the 1718?
That is correct.
Okay. Thank you. Thank you, Mr. Chairman.
Thank you, Senator.
Oh, wait, I'm sorry.
Go ahead,
to go on a little further then, you're going to do some improvements in your e-filing and technology, and I'm sure that's way overdue, but are you utilizing DoIT, the state agency, Department of Innovation, for that, or are you going out for bid on those projects?
For the additional e-filing, we do have service vendors already that we work with, and the judicial branch has their own technology, Judicial Management Information Systems division that handles the support and technology for the judicial branch.
But that was an audit finding, wasn't it, of the security of your system?
The security access, yes, that was. And that we have changed, updated procedures and protocols with that, and that was actually for systems access with other state entities' systems.
Then in your review to determine to use an outside vendor, do you utilize the state agency?
We do an RFP process, and we also do utilize CMS's bids as well, state master contracts. We do all of that as well.
So how how are you not utilizing the Do-It system?
We utilize the Do-It system for the ERP SAP system, the accounting system.
But you're not using it for your payroll? I saw in here you're not
No.
using it for other court proceedings and filings. That's my big, how are you not using the Do-It system that is a requirement by most departments?
As the third branch of government, we've had our own separate payroll system, legacy system that is maintained in-house. It is an in-house system.
Okay. Thank you. Thank you, Mr. Chairman.
Thank you, Senator Murphy. Chief Justice, I appreciate you being here. This was a robust discussion about your request and the work that the court is doing. We want to thank you as our co-equal partners in government for the work that you are doing. I will put a shameless plug in right now for those CLEs for pro bono work. I think that there were many of us who would benefit from that. So I would encourage the court to explore that vigorously. Seeing no further questions, Your Honor, any final statements?
Well, Mr. Chair, I want to thank you and your colleagues for having us here this morning. As I pointed out earlier, I feel like I'm at home in the old Supreme Court courtroom. And thank you for giving us all this time. And please have a nice day.
You do the same. Thank you, Your Honor. We do have a presentation from the Probation and Court Services Association who would like to testify relative to Senate Bill 4077. Carla Staniker, President of the association, and Mark Jarmer. Josie, you want to grab that? Members, if you be patient, we have a handout that's coming to us. With that, Madam President, if you'd like to proceed, please go ahead.
Thank you, Chairman Sims, Minority Spokesperson Rose, and committee members. My name is Carla Stoniker. I'm the Chief Probation Officer in Clinton County and the current president of the Illinois Probation and Court Services Association. We represent nearly 1,900 members, over 3,000 probation officers serving in all 102 counties. With me today is Todd Dillard, the Director of Morgan County Court Services. He is the immediate past president of IPCSA and our current co-chair for our legislative committee. And we're here today to support the Supreme Court's budget. I respect that your schedule is tight, so I've submitted written testimony, but I wanted to be here in person today to tell you who we are, what we do, and why probation funding matters. Probation officers are a highly skilled and professional workforce serving under the chief judges. Our role is to hold individuals accountable while helping them change behavior. We conduct risk assessments, develop individualized supervision plans, and provide cognitive behavioral interventions at a minimum. We also play a critical role in specialized treatment courts like drug court, mental health court, and veterans court. Today, probation is the most common felony sentence in Illinois, with approximately 68% of individuals convicted of felonies being placed on probation instead of in prison. And it works. Probation reduces recidivism and costs far less than incarceration. Currently, Illinois spends roughly $89,000 annually per inmate for incarceration, while probation costs roughly $3,800 per year. Even specialized treatment courts cost less than $10,000 annually per participant. For instance, the cost of treatment courts in Kankakee, Will, and Champaign counties range from $2,000 to $5,000 per year per participant. Yet, despite actively supervising the majority of this population, over 100,000 people, probation receives only 7% of the state's total funding for jails, prison, and probation. Probation keeps people in their communities, working, supporting their families, and contributing to local economies while improving public safety. As you consider the judicial budget, I urge you to recognize probation as a high-impact, cost-effective investment that strengthens communities in your districts and across Illinois. Thank you for your time, and I support everything that the Supreme Court has proposed, and we are happy to answer any questions that you may have. Thank you.
Thank you, Madam President. Questions from members? Senator Turner?
I'll make this fast. Thank you for your service. God bless you all. I've been there. Anyway, I just want to ask, what's the average salary for a juvenile and then for a regular probation officer?
I think there's not a lot of difference between the juvenile and adult salaries. However, there's a lot of difference depending on where you are in the state. The more southern you are, the lower the salary, the lower the cost of living.
And why is that?
I don't really know. I think it has more to do with the cost of living.
Because isn't that set by the AOIC?
It's set by the chief judges.
So there's no nothing in the statute that says that if you're a probation officer, you make X?
That's correct. Huh. There's a salary subsidy position that's a reimbursement position.
That's usually a secretary, though, isn't it? Isn't that the subsidy one?
No, that's probation officer.
It is a probation officer.
Part of probation. Go ahead, Todd.
Well, sorry to jump in here. So there is a base set by statute, but
Okay.
it's so outdated. I want to tell you, it's like, it might be $21,000.
Or 17,000.
I started at 17.
Yeah, that's what I started at also. Yeah,
27.
So that's how long it's been since that's been updated.
Yeah, and the counties are like the other county offices are the same way. There's I was just kind of curious, but so the way they set that salary, I know they have an increase every year. That's the same as what the state increases, isn't that right?
It depends on the chief judge in each district. Like in our area, the chief judge will approve whether we get a COLA raise, which is the same as what the state would propose for COLA. And then if we get merit raises on top of that based on the budget. And then some counties are union, so they get a standard union raise. Some counties are not. Some probation officers are grant funded, and they may or may not get raises depending on grant funding. And then salary subsidy positions, 12,000 of that is reimbursed by AOIC, and the rest is picked up by the county. So then the county can determine. So salaries
All over the
range
board.
all over the place.
Thank you. I appreciate it. Thanks for what you do.
Thank you.
Thank you, Mr.
Thank you, Senator. Those questions were clarifying. I appreciate that. Seeing no further questions, thank you, Madam President, for your attendance here today. We appreciate your support of the appropriation.
Thank you.
Members, we will move to our next order of business, which is Senate Bill 4078, the Office of Statewide Pretrial Services. Director Cara Smith and her team. Director, Your Honor, floor is yours.
There we go. My apologies. Good morning, Chairman Sims, members of the committee. My name is Cara Smith, and I am proud to serve as Director of the Office of Statewide Pretrial Services. I'm joined today by our Chief of Staff, Joanne Olson, and our Chief Financial Officer, Todd Miller. Before I begin, I must express our profound gratitude to Chief Justice Neville and the Supreme Court for their tireless support and for prioritizing pretrial services across Illinois. I would also like to thank each of you and your colleagues in the General Assembly for establishing us as an independent agency within the judicial branch effective July 1st, 2025. Our success would not have been possible without you. While Illinois' Pretrial Services Act took effect July 1st, 1987, it wasn't until recent years that the statewide vision for pretrial services became a reality when the Supreme Court created us in 2021. Today, OSPS ensures direct pretrial services, investigations, and supervision are in place in every county and every courthouse across Illinois. We are currently the direct pretrial services agency for 84 of Illinois' 102 counties, covering approximately 4 million residents and 45,000 square miles. We also reimburse salaries for approved pretrial positions in the 18 non-OSPS counties, including 352 positions in Cook County alone. We also provide training and technical support to staff and local stakeholders. We also have compiled the most transparent and comprehensive pretrial data dashboard available on our website, www.ilosps.gov. The need for pretrial services has been tremendous. Just last year, we experienced a 23% rise in pretrial investigations, 32% rise in total number of cases ordered to our supervision, and a 65% rise in total supervised cases ordered to GPS supervision. We also added 3 new counties, Macon, Tazewell, and most recently McHenry. Today we have 9,000 defendants on supervision. Of that, 2234 defendants with over 2,700 cases on GPS supervision, including 100 defendants we monitor in 24 states outside of Illinois. Our top 5 counties by GPS caseloads are Will with 683, St. Clair with 222, Peoria 145, Sangamon 119, Kankakee with 113 cases. We take a comprehensive view of pretrial services, recognizing that if we don't try to address some of the underlying issues defendants face, we will get nowhere. We want defendants to succeed. This is safer for our communities and better for justice. Last year, we sent over 81,000 court date reminders. We use a text messaging application, about 1,560 a week. We fund 14 client advocates and public defender offices in 10 counties in Illinois: Adams, Champaign, Effingham, Jackson, Peoria, Saline, Sangamon, Will, White, and Williamson. We provided more than 2,200 personal care kits to homeless defendants and provided transportation assistance in 7,376 instances, allowing defendants to get to court and other essential travel. As our reach and services have expanded, we've seen opportunities to partner with our local stakeholders to address public safety issues. We are collaborating to collect fingerprints from defendants who were cited and released in the field to ensure that their dispositions are recorded in their criminal histories. We have a very active pilot program in Macon County and have collected 208 sets of fingerprints and their corresponding document numbers to the circuit clerk, and we intend to expand this across all of our counties. We've recently been approached by the state police and the state appellate prosecutor to work with them and collect pre-conviction DNA samples in a handful of serious offenses that allow for that pre-conviction DNA. Our pilot program in Sangamon County is going to start later this month. We also are honored to serve as the incubator agency for the FAIR Act that the Chief Justice mentioned, and we are committed to providing the same comprehensive support to ensure that legislation is effectively implemented that the AOIC provided to us. A high-level overview of our FY27 request. As a reminder, all the services that we provide are free to the counties we serve and free to the defendants. And approximately 9 out of every $10 of our budget goes directly to providing pretrial services. Our FY27 budget request of $87.1 million includes $38 million in statutorily mandated salary reimbursements for 462 approved pretrial positions in the 18 non-OSPS counties. This is an increase from FY26 to cover full salaries of newly added positions in Cook County to support the expanded electronic monitoring program under the Chief Judge in Cook County. Our appropriation request includes $31 million in funding for 428 positions within OSPS. The personal services line includes 48 new headcount to support additional frontline staff, supervisors, and improved case management for our high-volume counties, including Adams, Champaign, Coles, Joe Davies, LaSalle, Marion, Richland, Sangamon, Will, and Whiteside counties. 24 positions are requested for the possibility of additional counties transitioning from a reimbursed county to an OSPS county. And our contractual services line includes 73 negotiated leases across Illinois, GPS tracking, alcohol monitoring, and our statewide case management system. Again, thank you for your support, for the opportunity to serve the judges and other stakeholders across our 84 counties. Personally, serving in this role has been the greatest honor of my career, and we are happy to answer any questions you may have. Thank you.
Thank you so much, Director. Senator Ventura.
Thank you, Chairman. Thank you, Director, or Your Honor, for being here. My question, same as last year, is my district is in Will County, and we have the highest electronic monitoring. I see your budget is increasing by $1.1 million. Last year, I talked to the chief judge to understand why we have such a high amount. His answer was that he would work with his judges in order to evaluate if that number was needed. It looks like it did not go down. So I want to understand better why my county of all counties is so high, and it's obviously affecting our state budget.
Yeah, it's a complicated answer. I don't ever want to presume that I would know more about a case than the judge or the prosecutor or the defense counsel. The state's attorney's office in Will County is aggressive in filing petitions to detain, and our analysis would suggest that when detention is denied, electronic monitoring is ordered. So we spoke with Chairman Sims about this, and our Illinois law does not contain what I refer to as sort of guardrails on the use of pretrial electronic monitoring. The Safety Act puts some important first steps in. The court must make certain findings that it's the least restrictive alternative. There is to be a review every 60 days about the defendant's compliance and whether that it remains the least restrictive condition. But the numbers are what they are. We work extremely closely with the Will County State's Attorney's Office and our stakeholders there, and do have a wonderful relationship. But our numbers are just objectively high in Will County and in other counties.
If there's any reason for your department to follow up with me on more specifics in Will County, I would welcome that. Thank you.
We would be honored to do so, Senator.
Thank you, Senator Ventura. Senator Murphy.
Thank you, Mr. Chairman. I just have a pretty simple question. What is your total head count?
Our total head count for FY26 is 357, and we are requesting an increase to 428.
So you're budgeting for 400?
428.
428.
Yes, ma'am.
What has your hiring experience been?
We are blessed with an amazing hiring team. It takes about 8 to 10 weeks from posting to onboarding. So this year alone, since July 1 of 2025, we have hired 66 staff.
So you are exempt from the CMS hiring processes?
Yes, ma'am.
Okay. Thank you. Thank you, Mr. Chairman.
Thank you, Senator Murphy. Director, there is also an initiative dealing with mental health support services. Can you walk us through that? I mean, we spent quite a bit of time this morning talking about the specialty courts, but also the mental health supports that are needed for defendants or the individuals that you come into contact with. Could you talk through that with us?
Absolutely. As the Chief Justice and my former colleagues from the AOIC were discussing, mental health is a significant issue in every single one of our counties. And our rural counties have the least access to services that they need, both assessment services and treatment services. So we issued a request for information to identify providers that may be willing to work with us to more expeditiously provide treatment and assessments to our clients. And we are moving forward in a partnership with Egyptian Health in Southern Illinois to hopefully jumpstart and expedite how quickly we can get defendants who have been ordered to get an assessment assessed and then get treatment in place. Having worked as director of the Cook County Jail, I can speak with firsthand experience that the majority of individuals in that jail and the majority of individuals that we encounter are suffering from some sort of mental health need, which is why we put the client advocates in those 10 public defenders' office. They're working to also address collateral issues that our clients face, and we're very hopeful that we can expand and build on the Egyptian Help Partnership. And thirdly, we are working with TASC, who has a Pretrial Success Act grant in Will County, to create a pipeline for defendants to receive services under that grant that they received. But I think it's fair to say that we can't do enough to address that need in all 102 counties of the state.
Well, thank you for that, and I think it's important that we recognize the efforts that need to happen, because oftentimes the individuals who come into contact with our criminal legal system suffer from some mental illness, and it's preventative on our part and cost savings for taxpayers if we address these issues and we provide those supports, so we don't have this revolving door into our criminal legal system. So I appreciate that, and I wanted to make sure that we had that discussion on the record, because this is an area that you are investing in, and I want to make sure we have that discussion.
Absolutely. Thank you, Chairman.
Well, thank you. Madam Director, I don't see any other questions, so we appreciate you, and we look forward to having the discussion with you in the future.
Great. Thank you very much. Thank you, members of the committee. Have a wonderful day.
Thank you. You too. Clerk, please ask Senator Aquino to the roll. Members, we will move to Senate Bill 4164, the Illinois State Appellate Defender. Presented by the state's appellate defender, James Chad, and his team. Defender, floor is yours.
Thank you. Thank you, Chairman Sims and members of the committee. Thank you for hearing from us today. I'm Jim Chad. I'm the director of the State Appellate Defender's Office.
Is your microphone on, Defender? Is that green light on?
The green light is on.
Pull a little closer for us.
How is that?
Perfect. Thank you.
Okay. I have trouble with this every year. I'm not sure why. Anyway, I'm Jim Chad. I'm the executive director of the State Appellate Defender's Office. I'm here today with Jana Berg-Schneider, who's our chief fiscal officer. So today I'd like to give a brief overview of our agency and then discuss a proposed budget for fiscal year 2027 and then take any questions that this committee has. The Office of the State Appellate Defender is a statewide public defender office that does criminal appeals for indigent clients throughout the entire state of Illinois. We were created in 1972. We have 5 offices throughout the state, corresponds to each appellate court jurisdiction. We have an office in Chicago, which is the 1st district, an office in Elgin, which is the 2nd district, an office in Ottawa, which is the 3rd district, an office in Springfield, the 4th district, and an office in Mount Vernon, which is the 5th district. We also have an administrative office in Springfield. We currently have 292 employees, 224 attorneys, and 68 support staff. Our budget request for fiscal year 2027 is $40.2 million. It's an increase of $1.9 million or 4.8% over fiscal year 2026. This budget allows us to be fully staffed, and it allows us to increase our pay plan, which will keep us competitive with other similar comparable organizations, especially the state appellate prosecutors, which is the closest comparison to us. Our 4.8% increase is almost entirely in personal services and Social Security and reflects the increase in our pay plan. Personal services will increase from $29.3 million to $31.3 million, an increase of around $2 million or 6.29%. Social Security likewise will increase $2.2 million to $2.24 million or 7.19%. Our travel budget will also increase from $47,000 to $60,000. That's an increase of $13,000 or 22%, and that's based entirely on the new reimbursement rates allowed by the state. Our expungement increases from $258,000 to $271,000. That's an increase of $13,000 or 4.7%, and that reflects increased salaries for the personnel in the expungement unit. And finally, public defender training increases from $173,000 to $188,000, and that's an increase of $15,500 or 8.2%. And that reflects increased travel costs for our conferences and for bringing in more experts. All the other line items are decreases and reflect our efforts to be diligent in our attempt to reduce expenditures where we can. I should point out that we are in the early phases of negotiating a collective bargaining agreement with our attorney staff, which is represented by AFSCME. Is it Council 31? Council 31. As I said, we're in the very early stages of negotiating that. We think it will take realistically several months before we have a collective bargaining agreement. I expect that implementing and funding the agreement will be the biggest challenge that we face this year. So that's an overview of our current budget, and I'd be willing to take any questions that this committee may have.
Questions from members? Senator Ventura.
Thank you, Chair. Sorry for my ignorance in this. I know the state a few years back changed the way that we have sheriffs get paid at the county, and I'm wondering if the public defenders were changed to some type of state statutory amount where the state might pay a portion of that, or how does that cost work on the public defenders?
So I believe what you're talking about are trial level public defenders. We're entirely state financed.
Okay.
We do nothing but appeals, and we're entirely state financed.
Okay, thank you.
Senator Ventura. Senator Murphy.
Thank you. I heard you say you have 292 employees. Is that the number you've budgeted for?
Yes, currently.
Okay, great. Thank you. Thank you, Mr. Chairman.
We have budgeted for 305.
Oh, you have budgeted for 305. Yes. Okay.
That's why I bring my CFO with me. So
Okay.
305 would be the head count the total head count that we have.
Okay, thank you. Seeing no further questions, Defender, we appreciate your presence here today, and we look forward to talking to you soon.
Okay, thank you. Can I say one thing about the pretrial fairness?
Absolutely.
Before I go? From our perspective, as a public defender, I've been a public defender my entire career for 41 years. It has been one of the best pieces of legislation I've ever seen. It's made a tremendous improvement in the lives of our clients. Clients now are kept in custody if they're dangerous or if they may not show up for the hearings, for further hearings, but they're no longer kept in custody just because they're poor, which in the past always resulted in ruining their lives. So we thank you for passing that law, and it's made a huge improvement. So thank you.
Thank you, Defender, for that. We appreciate it. Members, next we will move to Senate Bill 4123, the Illinois Environmental Protection Agency, with Director James Jennings and his team. Director? Director, floor is yours.
Thank you. Good morning, Chair Sims, Vice Chair Murphy, members of the committee. I'm James Jennings, and I'm honored to be serving as the Acting Director of the Illinois Environmental Protection Agency. This morning I have with me our Chief of Staff, Laura Roach, as well as our Chief Fiscal Officer, Max Paller. The Illinois EPA is one of the few agencies that touches each of the state's 12.5 million residents statewide every day. Our portfolio includes a variety of state regulatory environmental programs that govern businesses, communities, and residents statewide. In addition to that, we cover 90% of the federal environmental work that applies within the state of Illinois, including the Clean Air Act, Clean Water Act, Safe Drinking Water Act, and the laws governing hazardous waste. To achieve those objectives, we issue approximately 9,600 permits every year, and we conduct 4,700 compliance inspections to verify that these facilities are complying with state law and that our residents are protected. In addition to those responsibilities, we have a growing financial portfolio, which includes a wide variety of loans and grants that are issued to communities across the state to secure, among other things, lead service line replacement and needed enhancements to wastewater and drinking water utilities across the state. We have a diverse workforce of employees ranging from science, technology, engineering, and math fields, as well as a number of attorneys. Our current headcount is 831 employees. That includes 7 employees who are paid by the Comptroller's Office, as well as 28 members of the Pollution Control Board staff. Our proposed headcount for next state fiscal year is 852. That increase will accommodate our need to expedite permitting times, conduct additional rulemakings, as well as provide the necessary support to community relations activities around the state. Overall, we have both a capital and an operations budget. Our operations budget is $663.5 million, which is a little less than a 1% increase from our current fiscal year. That includes a total of $127.2 million in federal funds and $536.3 million in state funds. Of note, within this budget, we do have a 14% proposed increase for personnel costs. This is a reflection of the reality that over 90% of our staff are covered by the collective bargaining agreement between the state of Illinois and AFSCME, and those employees are entitled to both step increases as well as COLAs. In addition to that, we have a $38 million requested appropriation to utilize funds from a settlement between the state of Illinois and Monsanto. This was a settlement that was recently completed, and we are currently in the process of scoping projects that will be applicable to the use of those funds. Finally, and of great import to me, and from what we heard this morning from the Supreme Court, them as well, we are in the midst of a IT overhaul. Like many agencies that I'm sure that you hear from, our IT infrastructure involves a collection of disparate systems, many of which do not speak to one another, and that facilitates inefficiency and prevents us in many cases from being able to accept electronic submissions. Over the past year, we worked with DoIT as well as a consultant to be able to construct a request for proposals to ensure that we are able to provide the architecture for the IT needs of the state going forward in the most efficient way possible. That request for proposals is currently out for bid, and we anticipate having bids in-house by this time next month. Turning to our capital budget, our capital request for next fiscal year is $6.67 billion. Rather than itemizing all of the costs for you all, I just do want to highlight some that I know directly impact each of your districts, and that includes $338 million of a blending of state and federal funds for wastewater and drinking water infrastructure, loans, and grants, as well as $440 million for lead service line repair. These programs are vital to the future of the state as they both address historically deferred maintenance across a variety of communities, as well as serve as preventative maintenance to mitigate the possibility of further future state expenditures of resources. So I am happy to address any questions, and again, thank you all for your time this morning.
Thank you, Director. Questions from members? Senator Turner?
Thank you, Mr. Chairman, and thank you for being here today. We appreciate it. I have several questions, so I'm just going to ask you one by one. You just recently mentioned that wastewater and drinking water grant. Is that going to go to health departments to distribute that? I know I have a lot of rural, I have 10 counties, mostly rural, and a lot of times they're needing assistance in not the first test at their home, because that's part of what the health department does, but the second test, they're having to go to private companies to get that test, and they're over $300 to do. So is this something that will help with that?
So not directly, and that's largely a reflection of the combination of our authority and then where those authorities start to lean into the Department of Public Health. So these are awards for large-scale infrastructure enhancements, things like wastewater treatment plants, drinking water treatment facilities, sewer replacements, so larger capital projects.
Okay, so you're saying that that would be more geared toward Department of Public Health. Is that correct?
Correct. As a general rule of thumb, our authority ceases at the property line, and that's where public health would pick up.
Okay, I'll be asking them that question. Thank you. And thanks for helping me do that. You mentioned, let's talk about expediting permitting and things of that nature. Tell me how that process works, as opposed to a regular one. Okay.
Okay, so I think there's two components to that question. The first is that under state law, we have the authority to enter into agreements with permit applicants to expedite their permit review. The Environmental Protection Act, as part of that, creates a fee of 4 times the base permit fee. And in exchange for that, we're able to provide a mutually agreeable date by which we issue the permit to the applicant. That fee, though, directly supports employee overtime to be able to complete the project and to avoid a situation where we're sacrificing other projects. All of the work undertaken on that application is done during overtime.
So does that push back then the other ones that are in the regular process? Then that just, I guess, who pays more gets the best service? Does that make sense? See what I'm saying?
Yeah, so the process that we utilize is designed to avoid that. And so if you were to come to us with a permit application that you wanted expedited, it would be reviewed in an accelerated manner, but all of that review would occur during employees' hours outside of their work schedule.
Okay, so the other people that have permits in the queue, they're going to get the same treatment, but not the additional from the outside employees. Is that correct?
Correct.
Okay. Let's see. And tell me what a wait time is for, like, from start to finish. So when expedited and then regular. So how long does that take?
So ultimately, it depends on the individual type of permit transaction. Generally speaking, we have 2 broad types of permits, some that are subject to statutory timeframes, and then others that are more open-ended. In the most basic sense, the statutory timeframes that don't provide a specific end date are typically for more complex permitting transactions. In many cases, those are derived from federal law, and there's a recognition as part of that process that there needs to be either additional public outreach, the possibility of further evaluation of data that would require a more enhanced review that doesn't necessarily lend itself to a cookie-cutter approach.
And so air, water, and land are all different time frames?
Correct. Yes, it's based on the environmental media and the type of permit. So, for example, a landfill operating permit would have a different time frame than a construction permit under the Clean Air Act.
Do you feel like you have enough employees to be able to handle all the permitting processes that you have, both expedited and regular?
So I would never say no to more employees. Ultimately, it depends. There's a lot of factors that go into it. We could use more staff. It would enable us to be able to turn permitting transactions over quicker. We'd be able to avoid possibility of brain drain later on. And it would enable us to do additional public outreach that's necessary. So we're able to do the work that we have with the staff we have, but the reason for the request in headcount is directly tied to the notion that we need to be able to turn things around faster. And I know our Chief of Staff, Laura Roach, has done a tremendous amount of work on this and would certainly say.
Are there any permits that are like, what's the longevity of, like, the longest permit that's still hanging out there that just keeps getting continued? Are there some of those out there?
So yes, but there's some qualifications to that. So we don't have any permits that have been historically behind the 8 ball of a statutory deadline. What we do have, though, we have some permits that have been subject to either litigation during the pendency of the permit, and that has the effect of staying our ability to make a decision. In addition to that, we do have permits that may have a longer or don't have a statutory window for review. And during the pendency of the applicant comes to us with additional data that would inform the direction of the application.
So can they ride on that same permit and just keep getting it extended? Is that how that works? If you're permitted, but then you have more that you add to it, so you just keep getting that extended? Is that how that?
Generally speaking, yes. So if a facility is coming into us with a construction permit application, either for any of our media programs, they cannot undertake construction until they have a permit. Those are the permits that are typically under a statutory deadline, and we're able to turn them around within that window. Operating permits is where you get a little bit more potential flexibility. In those instances, once a permit application is in-house with us, the existing operating permit is continued for the duration of our review.
And how long is like the longest one that just keeps getting continued? Is there one that like, is there a point when it's like, there's one in the queue and you just can't get it done? Is there any of that?
So not that I'm aware of.
Good. Okay,
but
that's great. No, I just wanted to make sure of that because of, if you had a shortage of employees or whatever to get things done. And I enjoy working with you, and I know we've worked together in the past, and I appreciate it, and thank you for your staff and the work they do. Thank you, Mr. Chairman.
Thank you, Senator Turner. Senator Ventura.
Thank you, Chairman, and good to see you, Director Jennings. I have a number of questions as well. But first of all, thank you for holding the line on salaries in a kind of a tough budget year. I really appreciate it. I know you guys do a lot of work. My first question is the Monsanto settlement. First of all, I'm very glad to see that. Some of my first advocacy work was in fighting Monsanto and their some of the dangers they put onto our food products. Do you guys have any earmarks or targets where you might think that money might go?
So collectively, we have staff who are very eager to spend some of the money. Being $38 million and given some of the broader expenses for environmental remediation work, it only goes so far. I know our staff and our Bureau of Land, as well as Max's team, have been reviewing what options we have available, and so we're hoping to be able to finalize that. But there are no shortage of projects that we have internally that we think could be good uses of these funds.
Okay, so you're not necessarily tying it to where those products were used?
That'd be among one of the factors, yeah.
Okay, thank you. My next two questions are about the EV rebates on vehicles. So starting this year, we refocused the EV rebates towards lower and middle class drivers with a limited eligibility for more moderately priced vehicles. Those were all good changes. With the complete elimination, however, of the federal EV credits, which were up to $7,500 in August, incentives at our state would only range between $2,000 to $4,000 for low-income applicants. Is the state program having the desired effect in moving Illinois towards the goal of 1 million EVs on the road by 2030?
So we continue to see a high number of rebate requests. Historically speaking, this was a program that was aggressively and promptly oversubscribed. And Senator, as you know, the changes had the effect of being able to ensure that residents who were in most need of that financial support were able to access those funds. This state fiscal year, we had 2 windows of available funding. The first one closed relatively recently, and as part of that, every low-income applicant received a rebate, and then we were also able to fund all of the other eligible applicants. The funding window was reopened, and we anticipate that we'll be able to continue to spend that money. The broader reality around EVs is that there are a number of factors that weigh in to the market forces behind that. But our rebate program, combined with the reality that EVs are going down in price relative to internal combustion vehicles, we would expect to see a continued growth of both EVs on the road in Illinois.
Does the IEPA suggest any adjustments to the program, like increasing the rebates amounts or other changes, especially in lieu of the federal incentives, the loss of that?
So given the recency of when state law was changed, we're still gathering data on what additional changes may be necessary. But Laura does a tremendous amount of work in this area, so I would defer to her for some additional input.
Yeah, it's Laura Roach, Chief of Staff at IEPA. So, Senator, we're still having some discussions with the advocates on this, but I think the challenge in a program that, as the director said, it's a very dynamic market. We try to strike the balance between, last year we put some controls in place to try to stretch those dollars, but now it's maybe had too good of an effect, and so I know there's a desire for additional changes, but we also want to balance that with having the consumers to be able to have some level of expectation of what the program looks like. So it's been changed a couple of times. So that's something we're going to continue to look at. But, as the director said, we only have the data from a few months this year to look at.
And so kind of the same question, do you think that we can meet the goal of 1 million EVs on the road by 2030?
Senator, I would say it's a goal, and the state is putting a lot of resources and chasing after all the federal money that's out there that we can to try to sprint towards that.
Okay, well, I would like to keep an open conversation about what the state can do to try to meet that goal. My next question is about water. Are there additional grants for PFAS cleanup? I know that cleaning up PFAS is still kind of a questionable thing of how we do this. Could you talk about how the state might be addressing that issue?
Yes, so we have a wide range of mechanisms that we're seeking to employ. On the financial side, we do have funding available to address contaminants of emerging concern, which would include installing treatment technology at drinking water facilities and wastewater treatment plants to mitigate the amount of PFAS that could be either discharged or could be going through drinking water lines in the state. Beyond that, though, we've deployed a variety of regulatory mechanisms as well as permitting activities to try to minimize the possibility of further PFAS exposure. And that includes working with the pollution to identify larger sources of PFAS upstream, with the idea being that ultimately those could be potentially liable entities from which we could seek compensation to be able to directly address PFAS in these communities.
Thank you. And my last question is a more broad question, but with the changes of the U.S. EPA, what impacts have that had on our state EPA, and how might that impact us financially?
So this is probably the most common question that Laura or I get across the board. So it is two very different tracks. On the financial side, we do have a robust, federally supported financial portfolio. It does not make up the majority of our funding, but it is certainly a meaningful figure. Year to year, we've seen a slight decrease in the federal funding that would be used to directly support our personnel for our delegated programs. If that funding were zeroed out, at that, which was the initial proposal last January, that would certainly dramatically alter how we have to approach some of our programs. However, that proposition received bipartisan opposition in Congress, and the funding levels have been restored. And so if to date those core funding opportunities have been maintained. As we sit here right now, we have not had any significant volumes of federal funding drawn back. And we continue to work with the Office of the Attorney General in instances where there are threats of that to safeguard the funds that we received and are currently subject to legally binding agreements. Programmatically, as I said at the outset, the state of Illinois does 90% of the federal environmental work within this state. The regional administrator who works at US EPA's Chicago office has been very vocal that states are best suited to do this work. We agree. And so we've continued to maintain those programs. What makes Illinois different, particularly from some of our surrounding states, is all of these federal authorities are adopted into Illinois law through the Pollution Control Board process. And so as a result, any rollbacks that the federal government undertakes are not immediately effective here. They would go through a deliberative process, and we would be in the position, as would many other stakeholders, of being able to weigh in and identify instances where these rollbacks are scientifically or programmatically problematic. States like Indiana, Ohio, and even other similar states like Colorado don't have that same structure. And so as a result, whenever US EPA completes a rule that dramatically reworks that environmental regulatory regime, it immediately impacts them. So generally speaking, the way that we regulate the environment here is very much the same as it would have been 2 years ago. And that's a benefit. It gives some certainty to businesses, gives certainty to communities, and it ensures that we're operating in a manner that protects our citizens rather than operating out of administrative convenience.
Thank you so much for all those answers, and good to see you again.
Thank you, Senator. Senator DeWitt.
Thank you, Mr. Chairman. Welcome, Director. I just have a couple of quick issues I want to swing by you, and I'll be as brief as I can, Chairman. I've got a couple of situations in my district that I'm dealing with. And frankly, I wanted to ask these questions just because I'd be interested in your kind of 5,000-foot view of, are these issues standard practice for EPA, or do you think there are some issues that need to be more directly addressed with regards to process? The first issue I have is a groundwater issue on a former manufacturing facility in Geneva. It's currently being designed for a 40 to 50 unit townhome project on the fringes of downtown Geneva. Trying to get a NOFO or a remediation order or some final action by EPA has been a 7-year process. That, to me, sounds like an extremely long period of time for something like this. The specific issue is apparently groundwater. And what really surprised me, we had the developer down in November. We met with some of your staff. They were really good. But even since November, there has been virtually nothing processed moving forward. What struck me, in our individual offices, constituent services it'll make or break any elected official. I don't care if you're an alderman or a legislator, a member of the House or Senate. What struck me as notable in that conversation last November, in 7 years, not one EPA member of EPA staff, groundwater, licensing, otherwise, had even ever bothered to make the trip to Geneva and stepped foot on the job site. Ironically, all of these units are being built on concrete slabs. I have to believe, I know enough about this business to be dangerous on your end, but that strikes me as being a significant contributor to the process that this developer has been required to go through in an effort to get this piece of property approved to build on it. Does that sound like a normal process? I know my colleague Senator Turner asked about timeframes and schedules. 7 years sounds to me to be extremely excessive.
So I would want to get some additional information with respect to the specific site, and happy to do that and be able to get back to you. Depending on the specific remediation program that the site is enrolled in, that may be well within the bounds of what we would expect. Some of the most contaminated properties that come through our programs and that we partner with the federal government on can take decades to remediate because of the complexities of particularly groundwater remediation.
Mm-hmm.
That being said, as a general matter, these are sites that are able to be remediated certainly shorter than 7 years. And that's where, again, I would want to get some additional information.
Yeah.
I will note that over the last year, we've been working with the Illinois Housing Development Authority, consistent with the governor's broader directive to try to help accelerate housing growth within the state. And our staff have been putting an emphasis on turning these specific kinds of projects over quicker. And so to the extent that this would be a potential issue that is capable of replication, we're trying to design our programs to avoid that. But certainly we want to get some additional information because groundwater is particularly difficult to remediate. But at the same time, we also have a housing crisis, so we need to be able to address. But happy to get back to you.
Sure, I appreciate that. And I can assure you, your staff has all of the information they need with regards to the status of this project. Ironically, the engineer working for the developer is a former EPA employee who actually helped write policy on groundwater issues as they pertain to EPA. This developer has been required to dig multiple wells to get deep enough into the ground to even try to ascertain whether, A, there's any groundwater to speak of. This is less than a mile from the Fox River, and it's well elevated above the level of the river. So everyone has been incredulous that there's even groundwater on the site. So happy to share you the additional information offline. My second issue, and very quickly, appreciate it, Chairman. The city of Elburn recently had their wells tested for PFAS. EPA tested 3 wells, all within 1 mile of each other. One of the wells tested positive for PFAS. Granted, a serious issue. I understand the importance, and I know it's been a big part of your agenda over the last couple of years, probably. Before the city even had an opportunity to order their own retest, I believe they ended up using the same lab EPA uses. Your agency put out press releases that notified all of the residents of Elburn, there's 8,000 or 9,000, maybe up to 10,000 at this point. It's a growing community. Before they could even order a retest, the press releases went out, and the mayor shared with me that it was absolute chaos at City Hall. People started calling, when are you going to send me bottled water? Can we bathe in this water? I mean, every question you could think of with regards to water, which of course is important, just hammered City Hall. The city eventually did reorder retesting. I believe they used the same lab. It turned out to be a false positive because that one test, after they tested it on both sides of the system, either inbound before the water purification system and outbound from the water purification system, they tested negative the second time around. My concern is the fact that these press releases went out, absolutely lit up the community, as well as the mayor's telephone at City Hall. They should have had an opportunity to find out if the test might have been a false positive. And just so you're aware, and I want to be totally upfront, I will be filing shortly legislation that will mandate an automatic retest by the EPA of any positive test for PFAS to alleviate this problem of over-alarming a constituency or a population of I don't care if it's 8,000 or 80,000. I think EPA needs to be very careful when they start putting out press releases regarding the potential for contaminated water in any community. I'm going to file this bill. I hope, and I'm happy to work with EPA to try to get this resolved, but I'm really hoping you can help me get behind this to make sure we're not ringing the bell and setting off sirens about a false positive test for PFAS contamination. Your thoughts?
So I and our staff would be very open to working with you on that. One of the complexities that we encounter as an agency, and all environmental agencies run into with PFAS, is the nuances of risk communication. So the press release that would have been issued in this instance would have been triggered by Section 25 of the Environmental Protection Act, which requires us as a matter of state law to issue public notices if, among other things, there is a known risk of contamination. And so that's an area where we wouldn't necessarily, under existing law, have a tremendous amount of discretion. That being said, those laws were crafted with a slightly different set of potential contaminants of concern in mind. And given the ubiquitousness of PFAS, the natural anxiety around that is slightly different. As an agency, we have aggressively worked with the Illinois Municipal League as well as many units of local government to help make sure that we're collectively on the same page on messaging. But given the recency of many PFAS testing, this is an issue that is very front of mind. And so we'll certainly be open to some further discussion.
Great, I appreciate that very much. How many different labs do you typically use across the state to do this testing?
So it depends. And that's mainly based on the specific type of testing that we're doing. We do have a state lab in Springfield that we use that is accredited for a wide spectrum of analytical methods, but it doesn't include everything. So for example, we don't have the capacity to do some types of air testing, but generally speaking, we are able to internalize nearly all of the water testing that our staff do, as well as the water testing undertaken by a significant number of public water supplies across the state.
Okay. And I know municipalities obviously do their own testing as well as part of the monitoring program that you require. Do you audit these testing agencies to measure their accuracy?
Yes. So as a matter of both state law and our federal delegation, we are required to do triannual assessments of labs statewide. As part of that, they're able to pare back their menu of available options, which can be weighed through a variety of factors. But we have a team of folks who go around the state to do those audits consistently. And then in addition to that, we're also audited by an independent body to confirm that we're able to continue to meet both US EPA standards and then the national standards that broadly apply to environmental labs.
Okay, very good. I really appreciate that background on both of those issues, Director, so thank you, and thank you, Chairman.
Thank you, Senator DeWitt. Senator Lewis.
Thank you, Mr. Chairman. Director, good to see you again. Always a pleasure. Appreciate your testimony that the federal government is not really impacting the state of Illinois, and that you're able to provide certainty to our residents through your efforts. But I am concerned in listening to testimony as well as constituent concerns about the throughput and timing of permitting in your office, and that we seem to have a certainty and process that if you pay more, you can get your permits faster. That may be a great short-term solution in my opinion, but in wanting to give Illinois residents equal access to your agency without having to pay more, is that the process you intend on keeping here in Illinois, or are you going to work on process improvement to improve throughput?
So the expedited permit review process is a statutory creature, and so that's something that we would continue to support. Nevertheless, though, we are aggressively working to improve our process, and it's incumbent upon us to do that for a number of reasons. We've come to you with a request for more staff, and so we recognize the reality that there is a natural expectation that there is a trade-off there. In addition to that, we've been able to grow our staff after some pretty significant historic declines over the preceding decade, and we want to be able to ensure that the staff who are new are trained in a manner that encourages expeditious and accurate review, and perhaps not other concerns that may have historically weighed down our processes. But beyond that, permitting expediency is both environmentally friendly and business friendly. And so we recognize, given our work as well as the governor's very ambitious economic agenda, that we have a role to play there. And so we want to ensure that we are providing permit timelines that are consistent with states around us. And from some of the broad work that's been undertaken by the Environmental Council of States, which is a group that has membership of all 56 states and territories, our permit turnaround time is competitive with others. But I would add to that I know I and many of our program staff are particularly competitive, and so we would like to see that be as collapsed as possible.
Thank you for that, but I just hope you can make expediting and payments for expediting services go away, and that we are competitive just as a agency, more so than our neighbors, here in the Midwest, because economic growth without having to pay more for it will make us more competitive here in Illinois and allow us to grow. So if you could continue to work on process improvement, greatly appreciated, at least from this senator. Thank you.
Yeah, absolutely.
Thank you, Senator Lewis. Senator Rose.
Thank you, Mr. Chairman. Welcome, Director. I would love to say that this is going to be pleasant, but unfortunately it's not. I've had 3 rather nasty experiences with the EPA in recent memory. One is the city of Lawrenceville, where you guys were apparently receiving forms from an unlicensed individual for 6 years without anyone realizing that he wasn't licensed, because apparently no one bothered to check. The forms at one point in time contain references for multiple years to individuals who are no longer there, and you guys knew that, and nobody checked. And at the end of the day, the water treatment plant gets shut down. The sewer treatment plant gets shut down. The town is thrown into chaos. And quite frankly, most likely all of this could have been avoided years ago had EPA done what it was supposed to do. Now, contrast that with the village of Atwood, who had an issue. They attempted to work with you guys, and despite doing everything asked, including spending a lot of money that a little tiny town of less than 2,000 people doesn't have to spend on engineering reports, gets a massive fine from the state of Illinois. And we try to work with you guys on this, and the bill gets killed over here because it's more important to penalize people and charge people who are trying to do the right thing money and fines than it is to get them to actually use the money to fix the problem. So in the village of Atwood's case, they were taking all commercially reasonable and diligent activity to remediate and redress the problem that they agreed with you they had, and yet they get penalized. Well, the taxpayers get penalized at the end of the day, paying fines that they don't have. I am beyond myself. I forgot. Last summer, and I will say to your assistant, who was helpful once she got involved in it, we had the entire city of Mattoon, Illinois, which is 35,000 people with no drinking water, and we got a never-ending change every day. Oh, you do this, you're clear. They do it. Oh, it changed. Sorry, tomorrow you got to do this to get clear now. And then that changed, and the next day you got to do this to get cleared. And so basically, the city of Mattoon went almost a week on the hottest week of the summer with no drinking water, and quite frankly, with huge thanks to the city staff, Rural King, that donated tens of thousands of bottles of water, people who are driving water in from other locations. And I know you're not IEMA, but we actually had water trucks sitting right there in Mattoon at the armory from the National Guard that no one could use to go get the water. But in that instance, the ball kept moving on what it was that the city of Mattoon had to do to comply, to reopen and get their water. I will say in that instance, I think the person sitting to your left, who ultimately intervened and got us a little bit of clarity, I hesitate, I do not, I can't imagine how much longer it would have gone on had she not intervened. This is nuts. On one hand, we're penalizing people who are trying to do the right thing. On the other hand, we're nowhere to be found. On the other hand, we don't know what we're doing when we show up. Explain to me why you deserve any amount of an appropriation.
So taking those in reverse order, just because given some of the chronology, I share your frustration with respect to what happened in Mattoon. Laura and I were in constant discussions about both what had led to that outcome and then the necessary postmortem to prevent it from happening again. I fully recognize that that does not mitigate any of your justifiable frustration. If we were sitting in the alternative seats, I would probably have been much more profane than you were, so I do appreciate that. Because the drinking water is one among the environmental protections that is contemplated by the constitutional right every Illinois resident has to a safe and healthy environment. And the lack of certainty behind that, as evidenced by some of the frustrations that we ran into in Mattoon, is not acceptable. And I agree with your assessment there.
One thing, it's Mattoon. It's a big deal. It's a big deal.
No. Mattoon, and apologies. Growing up in Kentucky, I know the pronunciation of individual cities is very imperative. On Appleton, I want to get some additional information because I share the broader objective of seeking compliance and seeking technical assistance over fines. There are areas in which, particularly within our water programs, that is a matter of our partnership with the federal government that we are compelled to pursue enforcement. Ideally, we are designing our programs to be working to the left of that. Our Bureau of Water has recently launched a capacity development group, which is targeted to do, among other things, ready communities to be able to apply for the necessary infrastructure loans, as well as to address on-site technical assistance. And so that broader thesis informs, I know, my and our staff's collective desire to not have to ultimately refer things to the Attorney General's office. Because you're absolutely correct. The funding that ultimately would have been used to pay that fine necessarily depletes funding that would be otherwise available for the necessary water infrastructure upgrades. And so that's something that is a broader compliance initiative we are seeking to develop. That being said, I do want to be able to get back to you in a responsive manner on the specific instances there to be able to step through why we made the collective decision we did, and also how it would look different going forward.
Well, on Atwood, I can tell you what it is. You guys have a policy that says if the corrective action isn't implemented within X days, you're fined. Well, the problem is in the case of Atwood, as is quite often, and I would actually ask the members of the committee to kind of pay attention to this because it's important, it's not possible. a lot of the times the corrective action that you are asking people to take just can't, it's not like flipping a switch. Engineering alone in this case exceeded the time frame in which you had to have this implemented. You guys knew that when you ordered it. You knew it was impossible for them to comply. As the chairman and I, who are attorneys, know, most of the time in commercial real estate, when someone is taking diligent effort, making diligent efforts, diligent pursuit, there's all kinds of magic words like commercially reasonable efforts. There's one, commercially reasonable efforts. To remediate or take care of or eliminate the problem, you work with people. And in the case in hand with Atwood, everybody knew, you guys knew, there was no way, literally legal impossibility, no way for them to comply without getting fined, despite all efforts to comply. And it's not their fault, but the engineering takes time. And it simply didn't have enough time to do it, which makes me think we're more worried about finding people than we are about solving problems. Now let's get to solving problems, because Lawrenceville has got a real problem. In 6 years of reports being submitted, and I'm not going to say definitively false reports, but reports that certainly weren't accurate, and nobody catches that in 6 years?
So, and I do want to be able to follow up on the issue with Atwood, because there is a world in which the specific revenue that we were seeking may be a part of a menu that US EPA dictates to us. And if that's the case, I think that warrants a broader conversation between us and our federal partners about ensuring there's an element of reasonableness within that process. If it's state specific, I can commit to you that we will be addressing that within our own authority.
Thank you, because reasonableness is all anybody ever asked for, and there was none given. Go ahead.
Yeah, totally understand. And so for Lawrenceville, I know that our staff have been aggressively working to both address the ongoing issues there, as well as to source what ultimately led to this. I know Laura has been running point on this, and so I will defer to her for further discussion.
All right, so Senator, I know you've met with our staff recently. Representative Niemerg has been involved as well. We've made a number of visits out to the site. I think you also know, with respect to the operator, there's also a process going on at this time at which the director will ultimately adjudicate that as well.
I'm aware of that. I think this one needs a serious review, because quite frankly, this could be any town in any part of Illinois. If no one's looking at the paper that's filed, then any town, I mean, just for you all know, the wastewater treatment system essentially blew up in Lawrenceville, Illinois, and then Johnny-come-lately on the spot shuts it down, yanks the guy's license, when apparently the reports being filed were inaccurate for over 6 years. And by inaccurate, I mean, in some cases, not even filed by a guy that had a license for 6 years. Okay. Now, I do have one last question. We have I find this amazing by Illinois standards. Well, no, I guess by Illinois standards, it's just run of the mill. We have a electric vehicle coordinator who makes as much as you do, Director?
So we do. And
the person makes $207,600 a year. They're the highest paid employee in your agency, equal only to you. Why are we paying someone $207,600 a year to be an electric vehicle coordinator?
So I think it helps to go into some of both the individual employee's background as well as the portfolio. So this is the second gubernatorially appointed position within the agency. Her portfolio includes not only maintaining the hundreds of millions of dollars of electric transportation funding that we coordinate, but she also oversees the EV work of every other agency that has such a program within the executive branch. In addition, she's also the only other employee who engages directly with the governor on his EV agenda. And so while I understand especially the comparison, this is an individual who is nationally and internationally recognized as an expert in her field, and came to Illinois for the specific purpose of undertaking this portfolio. And as a result of her work, we have seen dramatic increases of the electric transportation infrastructure statewide, as well as EV adoption.
Was it because of her work, or was that because of the billions of dollars in incentives that were given out for people to buy EVs?
I would say both. Part of the incentives were driven, and some of the federal funding we received were a direct result of her diligent effort.
Now, let me ask you this. But that's federal fund. I'm talking about the state EV credit for the state taxes.
So I would say they're hand in hand. Without some of her expertise, I think that the capacity to be able to effectively deploy those funds would be very limited.
And how many EVs does Illinois have on the road today?
Approximately 165,000.
165,000. And your goal is 1 million by 2030.
Correct.
And your 165,000 since this employee came in has gone up how much? Where did it start at? What was the base?
So I don't have the initial base, but I know year over year it's about 25% a year.
25%. So you added 40,000 vehicles when people are getting a tens of thousands of dollar tax credit to purchase a vehicle. Yet out of 13 million people in Illinois, you only added 40,000 vehicles?
I would have to check the math, but that running.
Well, I mean, 25%. I mean, if you're at 160 now,
yeah.
You started at 120-ish, right? 130, somewhere in there. So you've added 30, 40 a year. Yet despite all these incentives and the highest paid person in the agency coordinating it, no one's buying.
So I do want to push back a little on the no one's buying it. And as I noted earlier, there are a variety of factors that inform vehicle purchase decisions. At this point, the market is starting to lean back toward EV purchasing. As Laura said earlier, the 1 million vehicles a year is a goal. It's a goal that we still aspire to, and we're trying to deploy those funds as effectively as possible to be able to achieve that.
Okay. 2 last questions. I've never heard this phrase, direct gubernatorial appointment, before. How does that work? Is that in HR?
So it's a position subject to Senate confirmation. I should have been more precise in how I characterize that.
Okay. So it's appointed by the governor and then confirmed by the Senate. Okay.
Correct.
Now, if you're the Bureau of Water manager who's maybe incensed that they haven't had a pay raise to the tune of $207,600, and how does the staff feel about that? And how excited are they to go do what they're supposed to do on a daily basis when someone gets inserted over them in a single year making probably twice what they're making?
So generally speaking, I think that the work that our staff does is directly pulled, or that is motivated by their individual professional desires. One of the legacies of state government, for better or worse, has always been that there are different tiers of pay across the board. When I came to the agency in 2013, the highest paid employee was a permit engineer, so paid higher than the director. And so one of the realities of public service is that there's always going to be a situation where somebody may make more than you. I know engaging directly with our staff, they've been incredibly appreciative of the fact that Governor Pritzker and his team have continued to make sure that our staff and the staff at other agencies have their salaries keep pace with both the collective bargaining staff as well as to accelerate payment to reflect what they would maybe be able to see externally. And for that,
what's your intro level pay for water? Water. What's the entry level pay for a water manager, whatever the title is?
So the entry level position for a water engineer or project manager is a life science career trainee. I don't have that specific number in front of me, but could absolutely get it back to you. That's a figure though that's set by the collective.
Just ballpark it. 80, 85.
I think it'd be maybe a little lower than that, but I want to make sure that I'm giving you accurate information.
Let's just say 80 for the sake of argument. So that the guy making 80 grand who's in charge of reviewing things like water quality reports from water treatment plants, you think they're super excited about somebody walking in over them making $207,600 a year?
So in an agency of 800 employees, I think that it would be fair to assume some people would be frustrated by that. Ultimately, though, it's my job as well as the job of our team to be able to motivate around those difficulties. And one of the luxuries that we have in having a leadership team that are very experienced in state government is that this is a dynamic that we've had to manage in a lot of other ways before. And so we're just having to reapply some of those tools that we learned when, say, bargaining unit staff were making more than their bosses to a situation like this. But I would reiterate that I know our team really appreciate the efforts of CMS and the governor's office to help right-size those positions, because we are today in a very different salary dynamic and with tiered approaches than we would have been, say, 10 or 12 years ago.
Okay, I think I made my point.
Thank you, Senator Rose. Senator Ventura for a follow-up.
Yes, thank you. So the EV coordinator, correct me if I'm wrong, also handles all of the infrastructure and the grants that went through from the federal government here to the state. Could you speak about that a little bit?
Yeah, so we received just over $500 million in 2024 for a wide range of climate-related and electric transportation awards. That includes awards that directly support both electrified clean and dry ports, awards that would support installing electric trains, as well as a number of charging stations across the state. I know Laura has been working directly with her as well, and happy to have her flag any additional information that would be potentially relevant.
So it would be a fair assessment to say that you would need someone with high technical skills, financial skills, and a full understanding of the industry in order to make sure that $500 million was spent correctly.
Correct.
All right. And then the infrastructure is really needed to encourage the increase in sales of EVs, so people have the confidence that they can go where they need to go, correct?
Correct.
So you would say that this is a maybe very important role for the state to be able to meet its 2030 goals?
Correct, particularly given some of the geographic distribution of charging infrastructure.
Fantastic. And then the last thing is, it is correct that this individual did not take a pay raise, correct?
Correct. She took a pay cut.
Thank you.
Thank you, Senator Ventura. Senator Murphy? Okay.
To affirm, you have a total headcount of 831, and you've budgeted for 854.
852.
852. Okay, thank you.
Okay. Thank you, Senator Murphy. And Director, again, thank you for your presentation here today and for answering the questions. This was a robust discussion. We appreciate the opportunity to have that. We'll continue to have these discussions with you.
Thank you.
Thank you. Members, we're going to move our order of business to our next order of business. Staying in Senate Bill 4123, here from the Pollution Control Board, we have Barbara Flynn Curry, Board Chair, who is testifying. She's not here. Okay. We will have then Bruce Bennett. I'm sorry, Michael Makowski, who's a board member, who is also here to testify in her stead.
Chair Sims and distinguished committee members, I am Michael Mankowski, one of the members of the Illinois Pollution Control Board. Barbara Flynn Curry was on the call earlier, but she had to drop off for personal reasons. So I am joined by Bruce Bennett, our CFO, and Angela Tin, one of our other board members. So the Pollution Control Board is an independent regulatory agency responsible for protecting the environment and public health in Illinois by ensuring businesses, industries, and individuals comply with environmental laws and regulations. The board's primary responsibilities include developing and implementing policies and regulations to prevent pollution and protect the environment, conducting investigations and enforcing penalties for violations of environmental laws and regulations, conducting public hearings on environmental issues, and providing a forum for public input and comment, and providing technical assistance and guidance to individuals, businesses, and industries on environmental issues and best practices. Overall, the board plays an important role in protecting the environment and public health in Illinois by setting environmental standards and regulations, hearing cases and appeals related to environmental violations, and imposing penalties and fines for noncompliance. We appreciate your support of the work the board does. To continue this support, we are here today to ask for an appropriation of $4.9 million in fiscal year 2027. This is an increase of $202,000 or 4.2% from fiscal year 2026. This appropriation request has no general revenue funds. Funding comes from other state funds where the revenues are generated by environmental permit and licensing fees. The majority of the increase to our request includes amounts to cover an anticipated 3.5% COLA as dictated by the ASME contract, and its related increases in Social Security, retirement, and group insurance costs, along with a portion to cover some operational expenditures related to board hearings. I think those are mostly related to court reporter costs. By funding the board at this level, the state of Illinois ensures the continued enforcement of environmental protections that safeguard our communities and natural resources. This appropriation will help the board fulfill its mission efficiently and effectively without additional strain on the state. Thank you for your time, and we're happy to answer any questions.
Thank you so much. Board member, I don't see any questions. It sounds like you did a great job in the intro. So we're going to move on, and thank you for being here this morning.
Thank you so much. Have a great day.
Appreciate you. Next, I have members will move to Senate Bill 4174, the Illinois Power Agency. Brian Granahan and his team. Director? Floor is yours.
Wonderful. Thank you, Chair Sims, Vice Chair Murphy, Spokesman Rose, and honorable members of the committee. My name is Brian Granahan. I'm Director of the Illinois Power Agency, or IPA. With me today is our Deputy Director, Georgina White, our Chief Financial Officer, Kevin Hayes, then also our Legislative Affairs Manager, Katie Ostrowski. Wave. If you see Katie around the Capitol, she's kind of our eyes and ears down here, so make sure to engage her if you need anything from us. Thank you for the opportunity to present the IPA's FY27 appropriations request. So for background, the IPA is an independent state agency created in 2007 to develop and implement electricity procurement plans to serve the residential and small business customers of Ameren, ComEd, and MidAmerican who have not chosen to buy power from alternative retail electric supplier. Based on a recent study by Citizens Utility Board, since 2015, customers have paid over $2.1 billion more by taking service with competitive suppliers versus utilizing IPA-procured default supply rates. The IPA is also responsible for implementation of the state's Renewable Portfolio Standard, or RPS, to incentivize the development of new renewable energy projects around Illinois. In the past 2 years, we've awarded contracts that support the development of over 3,300 megawatts of new wind development in Illinois. Illinois is also now the Midwest leader in solar project development, with over 6,000 megawatts of solar projects already energized. You can see that on our clean energy dashboard, cleanenergy.illinois.gov. In this past year, our Illinois Shine Solar Incentive Program, launched in 2019, processed its 100,000th project application. We're also responsible for ensuring that the clean energy transition meets other critical policy goals. These include fostering equity in the clean energy economy, enforcing labor requirements, and enforcing consumer protection requirements. As of this week, I'm happy to report that we've now registered over 3,100 equity-eligible persons in our online equity portal, which you can see at energyequity.illinois.gov. And this past year also saw us launch 3 innovative new consumer protection initiatives, including a customer restitution fund funded through forfeited collateral from non-developed projects that has already approved over 168 claims. The IPA also implements initiatives to support the continued operation of nuclear plants in Illinois through the Zero Emission Standard and Carbon Mitigation Credit procurement processes, the latter of which has resulted in over $1.8 billion in bill credits to ComEd ratepayers since its launch. If you're a ComEd customer, I strongly encourage you to check your electricity bill, and you'll see a carbon-free line item adjustment on that bill and a credit back. In terms of agency management, we also had no audit findings in our most recent financial and performance audits. So now turning to our appropriations request, the IPA does not receive general revenue fund. Instead, the agency's activities are funded through fees assessed to bidders participating in our procurement events, application fees assessed to program participants, investment proceeds of the Illinois Power Agency Trust Fund, funding from the Energy Transition Assistance Fund, and reimbursements from Illinois Electric Utilities. 3 funds support the agency. We have a lump sum appropriations for each. There's the Illinois Power Agency Trust Fund, there's the Illinois Power Agency Operations Fund, which is Fund 425, and the Renewable Energy Resources Fund, which is Fund 836. I'll start first with the Trust Fund. Our request from the Trust Fund is the authorization of up to $12 million transferred from the Trust Fund into the Operations Fund. As actual investment returns from the Trust Fund will not be known until this fall, this amount is kind of a best-case scenario ceiling of investment proceeds. For the operations fund, we are requesting an appropriation of $77.6 million. This is an increase over last year, and there's three main drivers for that increase. The first is simply shifting Illinois Solar for All program administration costs that had previously been supported through Fund 836 and moving them over to Fund 425. The second is accounting for a potential transition in third-party program administrators who run the day-to-day operations of our solar incentive programs. Last summer, we determined that a single joint program administrator for both programs would, over time, be more cost-effective than two distinct program administrators. But the first year of joint program administration may feature substantial transition costs if the new program administrator is not one of our incumbent administrators, so we've budgeted for that contingency. Third is increased responsibilities under the Clean and Reliable Grid Affordability Act, or CERJA. The IPA's new responsibilities include developing an energy storage procurement plan, facilitating the development of new energy storage projects, and developing an income-eligible residential energy storage program, developing a customer-facing geothermal heating and cooling system incentive program to support Illinois homes and businesses, new procurements to facilitate the development of non-wind or solar clean energy projects, supporting the Illinois Commerce Commission in developing the state's first integrated resource plan, developing a study to examine Illinois leaving MISO and PJM and establishing an Illinois-specific independent system operator, and a number of other program changes and policy changes. Implementing these changes accounts for the remainder of our FY27 Operations Fund increase. Lastly is the Renewable Energy Resources Fund, or RERF. Our request is $53 million from the RERF. The primary use of the RERF is to support projects for the Illinois Solar for All program, which facilitates new photovoltaic projects for income-eligible customers in Illinois, with a particular emphasis on environmental justice communities. RERF money is drawn down until it basically runs out, so we use that money to support new projects until there's nothing left in the RERF, and then we just turn to utility collections to support the Solar for All program. While the $53 million is actually $3 million lower than prior year's requests, once accounting for the expenses shifted from Fund 836 to Fund 425, it's actually a $13 million increase versus prior years. And that's because we've seen a major surge in Illinois Solar for All program activity across the past year, with unmet budgets from prior years now being awarded through this program year's activity to support new development. With these additional awards, we now anticipate that the RERF will be fully committed through contract awards by the close of fiscal year 2027. So that concludes our opening remarks, and we're happy to answer your questions.
Thank you. Director, Senator Ventura.
Thank you, Chairman. I have a couple of questions. The first is the concern on large loads users and how it might impact the procurement and the cost of Illinois to procure its energy.
Sure. There's a few different things there, because this is kind of the biggest topic right now that I think is happening in the energy space, is what do we do about the fact that there's all this new large load coming online, primarily through data centers, though not exclusively so. Yesterday, the Illinois Commerce Commission was debating requirements that ComEd was putting together to kind of slow the queue associated with new large load customers interconnecting. I think ComEd said as part of that proceeding they have over 28 gigawatts of new large load customers seeking to interconnect, and their peak system demand is about 23 gigawatts. So they have more customers in the queue, or at least more load in the queue, than they actually have available to serve it. Right now, as it stands, we are doing what we can to facilitate the development of new supply. We have that through two means. Number one is through the RPS implementation process, where we facilitate the development of new wind and solar projects. And number two is new power through CERJA to facilitate energy storage projects. That's what we can do at this point in time. Through integrated resource planning, also passed through CERJA, there may be the ability to try to facilitate additional supply if ultimately there's a determination of need in that process. That process is underway. The first IRP is to be filed with the ICC by December 15th, so we've got a ways to go in terms of the planning. As it stands right now, we are going to need to facilitate additional supply based on the low growth projections that we see. That seems inevitable. Just for a sense of context, the RPS budget uses as its denominator, the RPS goals use as its denominator overall retail sales in Illinois, and that's about 120 million megawatt hours right now. By 2031, we see that growing to 153 million megawatt hours. So you have to have some new supply coming along to try to meet all of that new demand. Traditionally, we've relied as a restructured market on competitive markets to produce those outcomes. Now we're starting to see a little bit more of a focus on using a centralized approach to try to facilitate additional projects, noting that the market signals from the competitive market aren't always producing those solutions.
So PGM is currently looking at some of their rulemaking, and part of that conversation has been about the new supply, making sure that it's not plants that were supposed to be retired just expanding, or making sure that we're actually bringing on new supply and maybe not opening old coal plants that had been open. Have you guys, has the IPA weighed in at all on any of the rulemaking for that part for PGM?
That's traditionally within the province of the Illinois Commerce Commission, but we've tried to participate with the governor's office on a few different points. So for instance, just recently, there was a proposal that PJM had put together that would have essentially projects that you would see in Illinois, like energy storage projects, move down interconnection priority relative to other fossil facilities that might be opening, new gas plants in particular. So we thought about writing a letter ourselves on this, but ultimately thought it would be much more powerful coming from the governor's office. So we worked with the governor's office, and the governor's office issued their own letter on that the IPA had reviewed and helped with some content for. It's tricky for us because we don't have a natural constituency. So to the extent that we can work with an elected official like the governor, it's much more powerful. And then the Illinois Commerce Commission is the entity with seats on OPSI and OMS. So they're the ones that are interacting on a daily basis with the two regional transmission organizations.
And in that same vein, they're looking at the auction of large users, possibly not having them be in an auction. How does that impact when you guys procure the energy or go to auction for the state?
It's tough to tell right now because there's two different proposals that are out there that we've seen, and we don't know what's going to be adopted, and we've asked for details about how exactly that would work operationally.
So have I.
Yeah, no one quite knows. So what we understood from one of the proposals was that you'd have this almost segmented off capacity procurement process for new large load customers. And we were just trying to understand the contracting mechanisms associated with that, because traditionally capacity procurements are one-year auctions, and this seems like it's more of a long-term revenue certainty play. And we don't know necessarily then what we would be doing in response to it. This has come up a little bit in the context of some of the legislative proposals where we've been asked for our feedback on those. We've kind of said, let's take a step back and try to provide a little more administrative flexibility because we're not sure what's coming out of the RTOs that we have to respond to. So we lock in a certain approach for how we want to manage new large load customers, and we don't know exactly what the RTOs are going to do. We may be in a position where we're not in a good position to respond. As it stands right now for our energy and capacity procurements, we only procure for default supply customers, which are exclusively small commercial and residential customers, and only those who stay with their incumbent utilities. So the IPA has never had responsibility around securing capacity to meet large commercial and industrial load. But there are provisions with integrated resource planning, other provisions in SURJA that could at least allow for potentially assignment of costs to those entities. And we know there's discussions continuing about how to potentially have them control for the market effects associated with new large load customers coming online by providing more of a cost allocation to those new customers.
Great. I have some legislation that I filed this year on directing the RTOs based on potential PGM rulemaking. I'd love to have the IPA look at that. Sure. But in that same vein, on the RTOs, part of SURJA was a look at having Illinois be an independent procurement of their own energy, similar to how Texas is. I know that's like a study you guys are looking at. Mm-hmm. Can you maybe give an update of how long that process might take and if it's begun?
By law, the first study, and I believe there can be multiple studies, if we find, for example, this is viable, then I think we have a second study that basically looks into how it actually would work operationally. That has to be published, I think, by December 15th. I think I might have misstated the IRP deadline. That's November 15th, and I believe this study is December 15th by law. So we're in initial conversations with the Illinois Commerce Commission about the ability to put something like that together. The good thing is, we have as our procurement planning consultants, E3, they helped us with our resource adequacy study. They've helped us with the development of our electricity procurement plan. They're sophisticated enough to be able to do this type of work. So we feel like we have the right team in place to examine the costs and benefits of going to a single state RTO. Taking a bigger step back, there's some arguments for and against this approach. So one of the arguments against might be that if we're serious about decarbonization and we don't have that many pathways to new supply, it might be helpful to be part of a broader energy market, because even if we're bringing more megawatt hours online through wind and solar, they may not be there to meet our peak demand, and we may benefit from having access to a broader system. The other direction, we are a net energy exporter. Right now, we produce about 185 million megawatt hours of power within Illinois. We consume total, including munis and co-ops, about 135 million megawatt hours. Yet we're paying much higher prices, especially in PJM, despite a surplus. So it isn't a good system right now. You have a bunch of data center development happening in the mid-Atlantic, and it's causing Illinois ratepayers to pay more. So a system that maybe doesn't allow us to be hostage to what's happening in other jurisdictions could be beneficial. And ultimately, it's going to take some time, I think, to analyze the full picture of all of this.
Well, and it sounds like your report will coincide with some of PGM's rules on whether they're doing an auction or a contract, and so that might be helpful for our look at future. I understand that we've benefited from exporting our energy, but that may no longer be the case. It'll be interesting to see how we move forward. My last question, we talked a little bit yesterday about it, and while I understand that your guys' salaries are not under the GRF, I asked this to a lot of agencies who have increases over the inflationary raises. If you wanted to speak briefly to the 7% increase that you guys have.
Sure, yeah, and this is something we talked about, and 7% is not what we're planning by any means. It's just what we had to budget for. We have a lump sum appropriation, and ultimately we don't know whether we're going to be offering merit-based increases each year. What we do every April is take a look and say, what's a reasonable cost of living adjustment? And Georgina and Kevin are both part of this process, and we try to look at different data sources. We look at inflation, we look at what the governor's office is doing, we look at what the collective bargaining agreements are, and then we try to determine what the right number is. I think it was 3.95% last year, I believe. And then we make a determination about whether merit-based raises may be considered. For a lump sum appropriation process, unfortunately, it's a little bit clunky and crude, so you have to kind of put a placeholder in place, whether you're going to do it or not, because we don't want to come back for a supplemental appropriation over something like this. So we've built something into our appropriations request that at least accommodates the potential for merit-based increases. That also kind of absorbs up things like promotions and restructuring and reclassifications and other things that wouldn't be considered a raise in the same sense. It would be more of a change in position. And that's what our ISL ultimately is intended to reflect. It may look a little bit different as far as how that works out. I don't know if there's more, Georgina or Kevin, you'd want to say at that point.
I think you pretty much summed it up.
Is your microphone turned on? And be very brief and succinct in your answers. We have another committee that we are bumping right now, so we need to get moving.
We get our guidance for our cost of living adjustment from the Governor's Office of Management and Budget. They issued a notice in October of 2025. And then we also look at the general market and we look at what the union employees are doing for the next fiscal year. We have no intention of giving merit increases across the board. Every employee is given a performance evaluation, and then their evaluation will reflect what they receive, if anything at all.
Thank you so much, Director.
Thank you so much, Senator Ventura, Senator Lewis. And again, members, we are up against another committee.
Thank you, Mr. Chairman. Director, mine, 2 questions. Please, yes or no answers. Okay? If I build a data center in my community, will my electricity rates go up?
From that local effect.
What is the local effect?
It depends on the size of the data center. I want to put that caveat on there because a 1 gigawatt data center is very different. Your local rates are not a function of the local data center, which I think is the answer that you're looking for.
That's the question.
All data centers writ large will create prices going up by virtue of supply and demand being recalibrated.
Okay. Second question, if we prohibit data centers from building in Illinois, but we allow them in other areas on, let's say, the PGM grid, will we prevent our electricity rates from going up?
We will not, and in fact, we've observed this directly. The capacity price increases that we've seen in PJM in particular are driven largely from large load customers occurring elsewhere within the region. And to Senator Ventura's point, that's one of the reasons why we'd look at a single state RTO is to say, hold on a second. If load going up here is creating a higher clearing price across the whole region.
In brevity.
Yeah,
right.
Thank you.
It's not my strong suit.
Well, no, Director, we appreciate that. We want to make sure that we get the answers, but we have an issue, and we can certainly talk to members after the committee. Senator Turner?
Thank you, Mr. Chairman. I just had a real quick question. You mentioned a letter that you were going to prepare, but instead you had the governor's office do that. What can you just summarize what that was?
Yeah, someone had reached out to us and basically said there's a PJM proposal that we think is actually somewhat harmful to the ability for battery storage projects to interconnect. And we've not traditionally...
Wait, I couldn't hear that last part you said.
Battery storage projects are looking to interconnect. Effectively, they'd be pushed down in priority. So Illinois passes surge on facilitating the development of new energy storage projects. And they'd be pushed down in priority, and other resources in other states that we put ahead of them in priority. We thought, well, This is something where I think we've heard from this body actually quite a bit. We'd like for you to be more involved with the RTOs in understanding what Illinois' policy priorities are so that systems that try to develop in Illinois can be faster to interconnect or don't face the same interconnection costs they would otherwise. And we basically brought this issue to the governor's office's attention, and we said, we think this is something that you may want to weigh in on because you're in a more square position than we might be to say what the state ultimately ought to be doing vis-a-vis an RTO. So we considered developing a letter on our own and saying this is what we're doing, and instead we just provided facts back because we thought it was probably more appropriate. If they chose not to do so, then we might have provided something that was more narrow from our perspective, so it didn't seem like we were speaking on behalf of the state. But it was just the sort of thing we wanted to make sure that we brought to their attention.
Okay, I get it. And the last thing I guess I want to ask, so when you have your next auction, do you anticipate then, I'm in MISO grid.
Yes.
Are electric rates going up?
It's hard to say right now. That the bid window, I believe, opens tomorrow, and then it runs through the end of April, and we'll get the reports. I think April 28th is when the reports will be released. We have seen prices rise in MISO pretty substantially over the last couple of auctions,
Right.
particularly during the summer period. What we're trying to do and what we can do is hedge as much as possible in advance for eligible retail customer loads. So for those customers that take default supply, trying to lock in prices in advance to keep prices down. It would not be surprising if prices continue to go up. There's no price collar within MISO. We've seen that instituted within PJM, where it's been agreed to between different PJM member states and the PJM board. That doesn't exist in MISO right now, but there is a cost of new entry that serves as a limitation. What you'll probably see, if I had to guess, and this is just purely speculation, I want to be very careful because the market should not take this as something that's certainly gospel, is similar to last year where you have the summer period with higher prices, but winter periods and the shoulder months with lower prices, and that's why you a very challenging thing, and we're trying to hedge in advance as much as we possibly can. We talked with Ameren about this at one point because theoretically they could blend that increase across the entirety of the year. Their view, and I think this is a justifiable view, it's not to say that it works out on balance, is that distorts the competitive market, because the competitive market ultimately, retail suppliers are picking up load kind of in response to that. They're saying, okay, you're gonna basically have lower prices in the summer and higher prices in the winter. You're going to end up with a lot of customer switching that might actually not leave people whole or socialize those costs where the prices are higher across a smaller customer base. So as it stands right now, that's just kind of the wave that we're riding on.
Well, respectfully, in MISO, since Governor Pritzker became governor, prices have almost tripled for electric. Went from 8.64 cents per kilowatt in 2019, ran up to 23 cents. And that's before we add $8 billion in batteries to it, which you guys say 10 years from now might lower my bill $1. So where does this end? When does it stop? Like when does it stop? When can I tell people that Illinois, because Illinois, and if you know this, sir, MISO did an entire study on this and said that Illinois is so distorted as a marketplace that we're now completely out of the entire average. And let me prove that point, actually. Indiana is at, 12.9 cents a kilowatt. Iowa was at 11.75 cents a kilowatt. Missouri is at 13.4 cents a kilowatt. Kentucky's at 10.88 cents a kilowatt. We're at 23. That's when does Illinois get to Kentucky? Everybody makes fun of Kentucky. We're not making fun for power bills. Their power bills are less than half what our power bills are.
I would like to talk with you about the data source that you're pulling the 23 cents per kilowatt hour from.
I would love to. It's this guy right here. But
price to compare, the Illinois Commerce Commission publishes a price to compare, and we have the tables in the packet right here for the Ameren Illinois price to compare. And it's between 10 to 12 cents per kilowatt hour. 12 cents has been the highest the price to compare has gone to. It hasn't risen above 12 cents a kilowatt hour.
Okay.
For what it's worth in Indiana right now, the Indiana Utility Regulatory Commission yesterday actually just held hearings on energy affordability. It's a major issue.
That's
there.
the summer-August price for Ameren.
That would make sense because that's when you're dealing with the capacity price spike for summer, but it's settled back down substantially since
right, but we're still completely out of line.
Well,
it's the rest of the Midwest.
As a restructured state within MISO, we're going to be in a very different place. We've deregulated our energy economy. So the State Public Utilities Commission isn't ultimately responsible for regulating generators for setting the prices of supply. We are exposed to the full market in a way that restructured states aren't. In restructured states, when capacity prices increase, the generators receive more payment, but the ratepayers is effectively a neutral exercise because that's kind of credited to that generator as though that's generator's extra revenue. In Illinois, the generator captures the upside associated with that, and the ratepayers.
So let's talk about generators, because the state of Illinois is scheduled to shut down a bunch of them in 2030. So if we're already the highest in the Midwest, once you shut down these remaining generators, and particularly in the MISO territory, other than, oddly enough, Illinois, of course, exempts itself from the list. Like the University of Illinois will still be able to burn as much coal as it wants to burn, despite all their scientists telling it's bad. But at the end of the day, like, you guys are the only ones that have any power. They have not power like electrical power, but political power to decide if these places stay open. I would think we need to send that message sooner than later that, hey, we can't afford this. And by the way, I didn't make that up. You made that up. You guys have a IPA report that MISO by 2030 will be fundamentally constrained by capacity scarcity. Now, I don't know what that means, because I'm just a simple kid from Charleston, Illinois, but I think it means that my power bills went up again. And everybody I represent, their power bills went up again. So every time we close one of these generators, power bills are going to go up. You have the authority to order these must run to prevent fundamentally constrained by capacity scarcity. When are you going to do that?
So as it stands right now, there's kind of a two-step process that's set forth in Section 9.15 of the Illinois Environmental Protection Act. It's a joint agency report. I just want to be clear between the IPA, ICC, and IEPA. Okay. Maybe more powerful in a sense.
Director, if you can make your answers succinct.
Sure.
And Senator Rose,
I'm done.
questions will close.
This is the single most important issue facing my constituents, is how much money they're paying their damn power bills. And I want the answer to this question.
Yeah. So we published our report December 15th, and we are scheduled to file a mitigation plan with the Illinois Commerce Commission in November, ideally joint with our integrated resource planning process. And in that plan, we'll publish a draft, I believe, in August. In that plan, we'll set forth any changes with respect to the decarbonization schedule that might be a result of the resource adequacy study and its findings.
Well, I'll tell you what the plan can't be. The plan can't be raise my power bills again. That cannot be the plan. people can't take it. I'm right against the Indiana border. People are moving across the border because it's cheaper. Everything's cheaper. But we're tapped out. So take whatever you're going to take away from this conversation today back home. We are tapped out. We bled all we can bleed. There ain't another penny, not a nickel, not a quarter, certainly not a dollar for higher prices in Southern Illinois. Central Illinois. Like Southern Illinois, that's even further south than me. It's worse. We can't do it anymore. You got to make some decisions. You got to give people some hope.
I appreciate your concern.
Thank you,
Director. What I would say to you and follow up to this discussion. The fact is, we know you are working hard to make sure that we are providing the best quality price for energy for homeowners across the state, homeowners and business owners across the state. What we ask is that you continue to double those efforts to make sure we are doing that work. Okay? Thank you. All right. Senator, we have to move on. We've got 3 more agencies, and we're up against Director, thank you so much. Next, members, we're going to move to Senate Bill 4117, the Executive Inspector General. In general, I would remind you again, we are up against some time constraints, so be succinct in your presentation.
Thank you. I'm Susan Haling. I'm the Inspector General for the Office of Executive Inspector General for the agencies of the Illinois Governor. With me is our CFO, Ogo Akpian, our Deputy Inspector General, Christine Benavente, and our General Counsel, Neil Olson. There's a lot of work that we do. And I have a presentation to explain all of that. Very proud of all the work that we do. I'm just gonna very worthy of the minimal increase that we need. And I'm just going to leave it to questions if you have about either the budget or the work that we do.
Thank you, General. Questions from members? Senator Ventura.
I have a quick one. When you guys give your report out on all of your findings, at the end of the year, it talks about cases that were dismissed or closed. Are the people who put in response or put in the complaint, are they then notified that their complaint was not investigated and has been closed out?
If a subject of an investigation has can reach out to us and ask for a status of a case, and we will provide them with that.
Okay, but you don't proactively let them know that it's been closed. Only if they ask for it.
The subject or complainant can statutorily can ask that of us. Otherwise, our information is confidential.
Okay, thank you.
Senator Ventura. Senator Lewis.
Thank you, Mr. Chair. Real quick, Director, nice to talk to you yesterday. Just for the record, in the Transportation Act that we passed in veto session, we brought your office in for oversight to the transportation agencies. There is possibilities to now eliminate you in a trailer bill. Do you agree or disagree that your office should be involved?
Thank you for that question. We have been involved in oversight. We have had the authority of the oversight of the transit agencies since approximately 2012. What went into the newly passed bill was that we didn't want to have overlap of that, and to try to ensure reducing resources and that we're not duplicating efforts, but also to ensure an independent oversight of the transit agencies as opposed to that staying in-house. And so we are against any changes of the current bill with regard to that aspect.
Thank you, Senator Lewis. General, seeing no further questions, we appreciate your presentation here today.
Thank you very much.
Members, we're going to move to Senate Bill 4076, the Legislative Reference Bureau. Director Jim Stivers. The floor is yours.
Good morning, Chair Sims, Spokesperson Rose, and members of the committee. My name is Jim Stivers, and I serve as the Director of the Legislative Reference Bureau, which is the Legislative Support Service Agency.
Jim, could you pull that microphone low?
Oh, yeah, I apologize.
Thank you.
Chair Sims. I'm the Executive Director of the Legislative Reference Bureau, which is the Legislative Support Service Agency that provides drafting services to members of the General Assembly. My realize you're up against a deadline today, so I just want to quickly mention that our fiscal year 2027 budget request is for $4,713,200, which will allow us to continue providing the competitive wages we need to retain and recruit members of our team, replace our 3 commercial copy machines, send interested staff to the NCSL conference, and cover increasing commodity costs and potential retirement payouts to staff. As always, I want to thank members of this committee for their continued support and partnership with the Bureau. It's a pleasure to work with each of you, and I thank you for your time.
Thank you, Director. Seeing no questions, we appreciate your presentation here today.
Thank you.
Thank you so much, and thank you for, and Jim, before you leave, thank you. We know we have put tremendous pressure on you and your staff to get bills drafted. I want to make and publicly thank you for all the work you and your team do to make sure that we have with the legislative initiatives we have before us.
Thank you, Senator Sims. I appreciate that.
Thank you so much. Next, we have we're going to stay with Senate Bill 4076, and Legislative Printing Unit with Executive Director Russ Nagel. Director, the floor is yours.
Thank you for your time. I'll be brief. My name is Russ Nagel, the Executive Director of the Legislative Printing Unit. We handle the printed product for the legislature, its members, staff, and joint service agencies, support service agencies. We're asking for a level funded budget, no increase over the previous year, and only one increase request for head count. I'm open to any questions.
Thank you so much. Seeing no questions, Director, but I will also thank you for all the work that you do to make those legislative printing initiatives go so well. Thanks so much. Members, seeing no further business to come before the Senate Appropriations Committee, committee stands adjourned.
This meeting of the Senate Financial Institutions Committee is called to order. The first order of business here, Paul Elders of Blue Room Stream has asked permission to video stream. Without objection, that permission is granted. Then we have a letter from President Don Harmon pursuant to Rule 3-2C. I hereby appoint Patrick Joyce to temporarily replace Senator Willie Preston as a member of the Senate Financial Institutions Committee. This appointment will expire upon adjournment of the committee on March 25th. So, clerk, please call the roll.
Senator Rose. You're welcome. Senator Lewis. Thank you. Senator Plummer. You're very welcome. Senator Ventura. You're welcome. Senator Solomon. Oh, come on. You're welcome. Senator Joyce. You're welcome. Senator Martwick. Senator Elman. And Mr. Chairman.
Present. For the record, there are 8 members present. That constitutes a quorum, so we can get on business. The committee will come to order. The following legislative measures will be heard today. Senate Bill 3019, Senator Joyce, and Senate floor amendment. No. Hang on a second. Is this a floor amendment or committee amendment? Okay, then. Senate floor amendment number 1 to Senate Bill 3903 for the Chair Walker. Senator as for Senate Bill 3019 from Senator Joyce, Senator Plummer and I have agreed to place this legislation on the agreed bills list. Senator Elman moves that Senate Bill 3019 do pass. Is there leave? Leave being granted. The bill will be so reported. Thank you. There's your thank you. Next, Senate Floor Amendment number 1 to Senate Bill 3903. Senator Elman is in the chair.
Does this thing work? Oh, there we go. Hello. Hi, thank you, Chair. We will now hear Senate Floor Amendment number 1 to SB 3903. Before you start, Senator, I'll announce the witness slips, and I presume you're going to present from your seat. There are 2 filing as proponents, 0 in opposition, and 1 filing with no position. Senator, Chair, please explain your amendment.
Senate Amendment 1 is an agreement among the parties that there will be a discussion process prior to the rulemaking that sets fees, as we discussed when the bill first came to the committee. We agreed to hold it on second, waiting consideration of amendment. This is the amendment, and I would ask for any comments.
Yeah. Is there any discussion? Senator Plummer.
Thank you. Well, first, Senator Walker, I'd just like to say appreciate the way this has been handled, the pulling it back and working with the opposition. The amendment you made, I think it was well received by some folks. Do you know if that cleared all opposition, or what's kind of the status there?
I believe it cleared all opposition. There is no witness that has slipped in opposition. I would say that some of the opponents didn't get quite all that they wanted, but we got to neutral.
I guess the other question I would have, and I think for those of us that are not in love with the agencies having some of this power and authority, we've probably lost that battle. We're probably kind of fighting a little bit of a retreat here. I know this is one of the last scenarios where that's not the case. This legislation would obviously end that. Any concerns from the proponents? I shouldn't say the proponents, but any concerns from you rather than leaving it to the legislature?
my thoughts on this is I understand there could be risk, but we've been operating primarily in this fashion for years. There's been good cooperation between the agencies and the industries affected. And so I think it's a good thing to do.
Is this your last bill?
Certainly not.
Oh, okay. Well, then I guess I'll vote no.
Would any witnesses like to testify? Any proponents? Any opponents?
Oh, please come forward and introduce yourself.
Again, Kurt Fiedler with the Illinois Financial Services Association. Again, we did slip no position. The amendment makes the bill better. It does force a meeting at least we hope before the filing of rulemaking. But again, to Senator Plummer's question, we still have general concerns about moving such legislative oversight over to rulemaking in this context, only because the way that JCAR process works, it really lessens the ability for us to have recourse if there's a disagreement with the administration that we are under. This administration, as Chairman Walker stated, we actually do work quite well with. They are quite responsive. They don't agree with us every single time, and we don't agree with them every single time, but at least they are open to working together, and that is in contrast to many prior administrations. But again, my fear is administrations change all the time. And so we may not have a favorable administration going forward, and the inability to have redress or recourse at the administrative at JCAR level is our primary concern, and that's why we opposed the original bill. Again, the amendment gets us as far as we can get with this particular piece of legislation, moving things to rules. It's a good first step. We'll see if we'll see if we have to make changes down the road, but at least we're gonna give it a shot. So.
Any further discussion? Thank you. Senator Walker to close.
I think this is a good bill as adjusted, and I appreciate everyone's efforts on it. I would
you. There being no further discussion, Senator Joyce moves Senate Floor Amendment number 1 to SB 3903. Recommend do adopt. Is there leave?
Leave? I'm okay.
Yes? Okay. There being leave, the amendment, with 8 members voting present, the amendment will be so reported. Did I get that right? Voting yes. Thank you. Now the amendment will be so reported. And I'll hand it over to you, Chair Walker, to close.
There being no further business in front of the committee shall stand adjourned. Thank you.